Good morning. Today is Wednesday, May 8th, 2024. I'm Eric Blank, and this is the Commissioner's weekly meeting. Commissioner Plant, are you ready to approve the consent agenda as presented?
I am ready to approve the consent agenda.
Commissioner Gilman,
Good morning. I would also vote to approve the consent agenda.
as would I. I think we're going to start with transportation number 4. Mr. Riley, a couple updates on TNCs and non-consensual tows.
Good morning, Commissioners. Nate Riley with Transportation Staff. We have a presentation for you this morning that will be covering two different topics, those being a revisiting of the towing-related data and a recent safety audit for a school TNC. We'll go ahead and start with the towing topic. If we could please share the presentation. Thank you. So based on the Commission's direction during the towing NOPR under proceeding number 23R0085TO, transportation staff has continued to aggregate and analyze towing-related data, including information from the Department of Revenue, DOR, and the PUC's own internal sources. The DOR data includes abandoned motor vehicle sales information for calendar year 2023, which supplements the same data received from DOR for calendar year 2022. Abandoned motor vehicle sales occur when vehicles are abandoned by the owner, which may include an inability to pay the applicable tow fees. The data includes information on the towed vehicles, as well as the MSRP and purchase price of the sold vehicles. The PUC's internal data includes a review of over 1,000 closed investigations, many of which included information on the towed vehicle and the origination address of the tow. We go to slide 2, please. So starting with the DOR data, we received information related to abandoned motor vehicle sales for the calendar year 2023, which pairs with the data we discussed several months ago that captured the same data from 2022. As you can see by the figures, there appears to have been an approximately 27% drop in abandoned motor vehicle sales from calendar year 2022 to calendar year 2023. However, despite this drop, the statistics show that the allocation of sold vehicles by model year appears to be fairly close to between these two calendar years. In 2022, approximately 78% of the vehicles sold were between 10 and 30 model years old, with the remaining 13% being less than 10 years old and the final 9% being greater than 30 years old, respectively. Similarly, in 2023, approximately 75% of the vehicles sold were between 10 and 30 model years old, with the remaining 16% being less than 10 years old and the final 9% being greater than 30 years old, respectively. Slide 3, please. Moving on to the specific vehicle models attributable to abandoned motor vehicle sales in 2023, the most prominent vehicle types of vehicles being sold were Chevrolet and Ford. There were also many vehicles sold that were manufactured by Toyota, Honda, Dodge, Nissan, Jeep, Hyundai, Subaru, Kia, and GMC. Slide 4, please. When comparing the 2023 data to what we already had for 2022, the specific vehicle models attributable to abandoned motor vehicle sales were almost identical, with the most prominent types of vehicles being sold being of similar makes. When taking the data from both calendar years into consideration, it also seems to be on par with some of the more popular makes being registered in the state of Colorado, so this distribution appears to be properly allocated. Slide 5, please. The two data points on this slide are the MSRP and the purchase price of abandoned motor vehicle sales. These are new data points that were only included in the most recent 2023 figures from DOR, so we cannot compare the information to the 2022 data as of right now. However, just looking at what we have for 2023, you can see that the MSRP of the sold vehicles were primarily between the $10,000 and $30,000 range at 58%. A quarter of the total percentage was listed at $30,000 plus, with the final 17% being $10,000 or less. And perhaps a more valuable metric is the purchase price, which is what is being listed on the DR 2173 bill of sale form with DOR for these vehicle sales. The data shows that over 80% or 4/5 of the vehicles are being sold for $2,000 or less. Of this 80+ percentage, 79% of the vehicles in that allotment are being sold for $1,000 or less, and 52% of the percentage within that allotment are being sold for $500 or less. Approximately 17% of the vehicles are being sold for between $2,000 and $10,000, with the final 2% of the vehicles being sold for over $10,000. It should be noted that pursuant to statute, just because an abandoned vehicle is being sold for an amount that's greater does not necessarily mean the towing carrier is entitled to a greater sum. The statutory guidelines for such situations, as found in Title 42, still only allow a towing carrier to be reimbursed for the amount of accrued fees and charges they are claiming for services rendered, as indicated on the DR 2173. So, for example, if a vehicle is sold for $10,000, but the towing carrier is claiming $3,000 in fees and charges, they would still only be entitled to recover that claimed amount. The remaining proceeds should then be distributed to the vehicle lien holders, vehicle owners, and other individuals who have financial interest in the vehicle as appropriate. On the opposite end of the spectrum, if a towing carrier is claiming that that same $3,000 in fees and charges, but the vehicle only sells for $1,000, they would only be entitled to recover that entire amount, but would potentially be operating at a $2,000 net loss for the services they perform related to that particular tow. Slide 6, please. The next few slides will be covering the same or similar data points as those just discussed, deriving from the DOR information. However, in this case, the information was extracted from the PUC's internal records, specifically towing-related investigations that have been resolved over the past 5-year period, from January 2019 through December 2023. In total, this included a review of over 1,000 different investigations involving many different towing carriers and circumstances. It should be noted that not all case records contained the relevant data points, but when they were present, they were extracted and included in the aggregate data. To the data captured in this particular slide, and referencing back to the DOR data, the model year of towed vehicles that were investigated by the PUC are broken out to 52% for vehicles between 10 and 30 model years old, 44% for vehicles less than 10 years old, and 4% that are greater than 30 years old. Slide 7, please. This slide shows the number of towed vehicle models being investigated over the past 5-year period. As you can see, the most prominent models being investigated are Toyota, Ford, Chevrolet, Subaru, Nissan, Honda, Jeep, Dodge, and Hyundai. As you may have noticed, this list of vehicle models is quite similar to the DOR data for both 2022 and 2023, which indicates a consistency in the data regardless of the source. Slide 8, please. A data point that was available in the PUC's internal records, which is not currently available in the DOR information, is the origination address of the tows. In this instance, the data was broken out by city. As demonstrated by the graph, the majority of the towing-related cases involved tows originating in Denver. The next more frequent areas were Aurora and Colorado Springs, followed by Fort Collins, Lakewood, Thornton, Pueblo, Inglewood, and Westminster. The areas from where the tows originate tends to balance out after that. Specific zip code information was also aggregated from these data points, and while it is not yet available, it is an ongoing project to try to overlay this data on other metrics that illustrate disproportionately impacted communities in order to see what trends may surface. Slide 9, please. Based on the review of these various data points, as well as comparisons between DOR and internal PUC data, we can start to draw some conclusions. However, we are still refining some of these data points and keeping our eyes open for other relevant information that could potentially be captured as part of this exercise. While we have learned some things from this data which has not been previously known, such as the general volume of abandoned motor vehicle sales in Colorado over a year period, there is still additional work to do and more to learn. We would like to take this opportunity to thank the officials at Department of Revenue for their collaborative efforts and data sharing in this area. We are encouraged by the relationship we are building with them and look forward to further group efforts. As stated earlier, we are also exploring ways to use this data to further pursue Senate Bill 21-272 initiatives, which will help guide the Commission policy considerations and other staff implementations. We will continue to build more perspective and understanding on these and other data points related to the towing industry, which can lead to a range of benefits and improvements to the regulatory framework. As a final point on the towing topic, it should be noted that the Commission still retains its audit authority over towing-related records under Rule 6007E. Through this authority, staff can invoke the parameters of this rule to collect information, documentation, and other records for a variety of purposes. As we continue to go down the rabbit hole, so to speak, with this data that is already accessible to us, we can make determinations on what other information may still be helpful or necessary as we make decisions and policies related to the towing industry. I will pause here for any questions, comments, or discussion before moving on to the second part of the presentation.
No, greatly appreciate the investigation, the data, before you did this, I had no idea whether there was 100, 1,000, or 10,000 abandoned vehicle sales resulting from non-consensual tows. So really, greatly appreciate you defining the extent of the problem, and would just echo what you said as a next step, which is if you could continue digging into whether the zip codes reveal a tendency to target disproportionately impacted communities, that would be greatly appreciated. And I guess my one question is, do you know why non-consensual tows and abandoned vehicle sales would have went down between 22 and 23? Do you think that's a pandemic thing, or we just don't know?
Yeah, it's hard to speculate. I mean, we can make a few assumptions potentially. So, for example, it could be due to some of the legislation that was passed back in 2022 that allowed consumers to get their vehicles back for less than the full amount and then pay the rest later. That could have impacted some of those numbers going down because in 2022 is when that legislation went into effect, and then like I said, we saw that about 27% or so drop from abandoned motor vehicle sales in 2022 versus 2023, when some of those provisions had been implemented and were effective. So that's a possibility. I would also, try to credit our team as well, because we get a lot of complaints that get filed, and we actually saw a spike after 2022 in the towing related cases that we saw filed with the PUC. And our staff at Consumer Affairs and also our Transportation Investigations team has spent a lot of time working with consumers and the towing carriers to try to get people's vehicles back when violations are found. So these could be contributing factors. We can't say 100%, but that's a possibility.
Well, I'd request that when it's time, if you could look at 2024 and see where this is all going, at least for me, that'd be greatly appreciated.
Yeah, and DOR seems open to that arrangement as well.
Commissioner Plant, questions, comments, concerns?
Thanks. This was really interesting, Mr. Riley. I appreciate the presentation. Is your subset of data, was that derived from, was it a single month that you did the audit on, or how did you arrive at your subset of data that you did the investigation on?
So for the Department of Revenue data, those were calendar year data sets. So part of it was something we actually had received earlier this year from DOR, I think in about January, and it captured the entire 2022 calendar year. And so about half of the data set derived from those 2022 figures and that data set. Whereas we essentially asked for the same data set for 2023. However, we had made that extra request to include the purchase price data, which hadn't been included in that initial 2022 data set. So we had that fresh look at actual purchase prices of abandoned motor vehicle sales, which I think shed some light on what these vehicles are being sold for, which you can make some assumptions about that, such as the condition of the vehicle when it was sold. So I think that kind of plays into kind of trying to navigate the fact that we don't have clearly defined differences within the data sets on when the vehicles are abandoned as, for example, a post-accident where it's just a completely wrecked vehicle versus just a non-consensual tow from a private property where the person just couldn't pay the amount to get it out. So I think we can kind of start looking at some of those purchase prices, and while it's not a 100% concrete delineation between the tow types, I think we can kind of start to infer from the data, what kind of quantity we're talking about that may be just a standard non-consensual versus like a post-accident law enforcement order tow, for example.
And did you see any, and I don't know if you had information that sort of drilled down seasonally, but was there a seasonal change in what you observed, if you got that information at all?
Yeah, we can certainly look into that. I mean, I don't know that was a data point we were looking for, but the aggregate data that we've received from DOR is is quite large. There's a lot of different data points to explore. However, we just kind of went through the data and kind of picked the ones we thought were most relevant to the discussion. However, you do raise an interesting point on, are there certain trends based on what time of the year it is? So yeah, we can certainly look into that, as we move forward.
Yeah, I'm just thinking, a lot of maybe the older cars, particularly that maybe are breaking down, I'm not speaking from personal experience here or anything, but the snow tires maybe are worth more than the car.
Sure.
And so they just sit during the wintertime. And then, it'd be interesting to see, I would imagine more accidents in the winter, more of an abandonment in the summer, but I don't know. It'd be just interesting to see if there are any trends there. Thank you.
Yeah, and there may be some data points we can look at to explore that.
I'd be curious about that too. Commissioner Goodman, comments, questions, concerns?
Yeah, I think kind of related. Well, thank you for the data, first of all. Very helpful to understand the issue better. And from your previous conversation, I was already going to ask, but it sounds like perhaps somewhat fair to speculate that the gap in MSRP to purchase price is probably primarily due to like totaled vehicles or severely damaged vehicles potentially, right? I mean, we're seeing a pretty dramatic number selling well lower than what the MSRP shows.
I mean, it could be that. It also could just be standard depreciation as well. Again, a large portion of these vehicles are in that older 10 to 30 model year range. So because of that, yeah, it could just be standard depreciation as well. That's not out of the realm of possibility.
So it's not really, you can't tell just from that. Anyway,
well, I think when you're looking at the purchase price itself, the lower it goes, I think the more likely it's possible that it could have been one of these post-accident vehicles that's just been completely totaled out. And it's essentially being sold for scrap because, once you get under the, probably $500 threshold, I imagine, I think it's probably a pretty decent chance that those vehicles being sold at that price or lower in some cases could just be they're selling it for parts or scrap. I mean, there's really no value to the vehicle at that point.
Okay, great. Yeah, and I certainly appreciate you drawing the line to our 272 work on disproportionately impacted communities and kind of the relationship that towing has there. In many avenues, we think of it in kind of the energy realm. And of course, we all know there are transportation and other regulated industry impacts to disproportionate impact to communities. And I think towing is very high on that list, in terms of actual impacts to folks' lives and kind of where we might be seeing disproportionate impacts by the entities that we regulate. So one thing I would add maybe to your future plans to track towing by zip code, if it could also be done by zip code per capita, understanding that there might be more densely populated areas, it stands to reason there are more cars get towed, probably proportionally, So I'm kind of interested in the proportionality, which you can't always tell just by zip code alone. So that would be just a helpful part to understand, so we don't overlook perhaps an obvious difference in density in areas that are being considered. But other than that, thank you very much for this. Helps me understand the situation much better.
Of course. If there's no further, oh, sorry.
I just one more comment on that. And the same on like models. If we know how many models are abandoned divided by the number sold, so instead of just saying, yeah, the most popular models are sold. So not just divide through by per capita by zip code, but also by number sold. If you have that data, that would be another way of normalizing that. So if possible.
Okay.
Well, and I know in some of the disproportionate impact community work, we're talking at more the census tract level. And so it might make sense to talk with some of the folks working on our equity initiative, see, how this can best be divided up. Sometimes a zip code can include a lot of different neighborhoods that might be differently situated. But if it's not possible and that's too granular, I get it. But it would be great to match up the level of granularity I think we're trying to get, across the board in terms of viewing impacts to communities.
Thank you, Mr. Riley. You want to go on to the TNC audit?
Yes, thank you. So turning to the second topic, which is a report on the recent safety audit that was conducted on a school TNC. On May 27, 2022, the governor signed Senate Bill 22-144, which allowed transportation network companies, or TNCs, to expand their operations into the school-related and government-related transportation markets, while still retaining full commission jurisdiction in these areas. This new legislation was effective immediately due to an incorporated safety clause. One of the requirements listed in this bill was for the commission to have promulgated rules related to the TNC's engagement in school-related transportation no later than September 1st, 2022. The commission enacted temporary rules related to this new TNC-related transportation, effective on the statutory mandated date, pursuant to proceeding number 22R0359TR, and followed up with a permanent rulemaking pursuant to proceeding number 22R0402TR. The permanent rules subsequently went into effect on April 30th, 2023, so a little over a year ago. Based on the statutory language, the commission was required to coordinate with the Colorado Department of Education, or CDE, when drafting these rules, which we did. Amongst other things, the new permanent rules require TNCs engaging in school-related transportation to conduct enhanced vehicle inspections and driver medical requirements, as well as more stringent background checks. The rules also required a more intensive driver training program, which is tailored towards school-related transportation, and daily vehicle inspection checks. The reporting of safety or security incidents is also mandated, both on an immediate, biweekly, and annual basis. Real-time GPS tracking of student rides is also a necessary safety feature, as illustrated in the statutory language and corresponding commission rules. On April 9th, 2024, the entire Transportation Investigations team participated in a safety audit of the school TNC Hop Skip Drive, Inc. This audit consisted of a review of the company's paperwork and demonstrations of its integrated technology as required by the new statutes and permanent commission rules. As part of the audit, the TNC arranged and facilitated the inspection of almost 50 different personal vehicles used in their school-related transportation operations. Taking all available factors into consideration, I am pleased to report the following. Overall, the investigations team was very impressed with the quality and condition of the vast majority of the inspected vehicles. In almost every instance, all required inspection criteria was either met or exceeded. There were a couple safety issues that were observed, such as worn tire treads. However, these issues were immediately reported to the respective drivers and the TNC for immediate follow-up. In addition, there was discussion with drivers about proper trade dress placement, which is the identifying markings on the TNC vehicles, as well as the availability of required documentation, such as medical certifications and vehicle inspections. In general, the drivers were found to be pleasant and cooperative, and the entire vehicle inspection process was facilitated by TNC staff on hand to provide assistance. As for the required TNC documentation, there were very few concerns, and the overall observations were that there was significant compliance with the new permanent rules, which are found primarily under PUC Rule 6724. Other than a minor issue of using the proper form to complete the requisite vehicle inspections, all other safety and administrative standards appear to have been met. This is an impressive feat, considering this was the first safety audit of this kind conducted on a TNC. Furthermore, the TNC expressed the desire to fully engage in collaborative efforts with the PUC to continue their compliance and further enhance the safety and effectiveness of their operation. At this time, I will pause for any questions, comments, or discussion.
Yeah, just really glad to hear this, given all the churn we had over legislation and the rules, and just really pleased to see this piece of our regulatory world go well. So thanks for being the bearer of good news, Mr. Riley. Commissioner Plant, questions, comments?
No additional questions, just similar appreciation.
Commissioner Goodman.
Yeah, thanks for this, Mr. Riley. And do you think these inspections might happen with some frequency in the future, or?
Yes, in fact, we discussed just that during this most recent safety audit. I think we're trying to come up with what we think is an appropriate schedule to go out and recheck, or maybe, since this is the first time, we gave them a little bit of advance notice, not too much, but we may be a little more impromptu in the future as well. But now that they know what to expect, we do expect them to fully comply and address the areas that we pointed out, which again, were few.
Great. And as you do this in the future, it's my understanding that the TNC in this case was able to select the vehicles that, that came, obviously considering availability and other issues that might naturally limit who can come. Are you able to ensure that there's kind of diverse sets of vehicles, in future audits, just to ensure we're getting like really a pretty broad cross section, not just kind of any that the TNC could consistently cherry pick.
Yeah, absolutely. And again, we were kind of trying as best we could to make our way through this first one. Like I said, this was the first safety audit we'd done on a TNC like this, so we kind of were putting it together as best we could. But yeah, no, I think that's a very good point, and I think we will definitely consider that in the future on if potentially we want to maybe have the TNC put together a more randomized sample of vehicles that would be available for inspection. But like you said, sometimes there are, scheduling and logistical concerns that go along with those kinds of efforts as well. So we have to kind of balance everything out.
Great. Well, thank you, Mr. Riley. Appreciate that.
Thank
And
you.
likewise, yeah, it seems like it should be a random view, not just cherry pick. So with that, thanks, Mr. Riley. Greatly appreciate it.
Thank you, commissioners.
Thank you. Let's go back to the top, transportation 23A-0549BP-TA Mountain Transport. Ms. Harper.
Good morning, Commissioners. Ruthie Harper of your Commission Council. For decision today is a motion from Mountain Transport requesting extension of the temporary authority issued by the Commission last November to provide contract carrier service between a Durango mountain community and Purgatory Resort. Mountain Transport's temporary authority will expire on May 13th, and it requests an extension until a final decision is rendered on its application for permanent authority. I do have a recommendation if you'd like me to proceed.
I would like to hear the recommendation.
I recommend granting the requested extension. It is troubling here that the carrier delayed so long in filing its application for permanent authority, which it only filed yesterday. Temporary authority, which is granted without the full participatory process, is meant to ensure that needed transportation is provided while permanent authority is being considered. Nonetheless, I see no compelling legal or policy reason here to deny the extension, which would have the effect of preventing this carrier from continuing to provide the service while its permanent authority is pending. There's been no opposition to this service, both the initial application and this motion, and the extension request states the service is needed to safely transport the residents of this community over the highway to the resort. So for those reasons, I recommend extending the temporary authority through issuance of a final decision on Mountain Transport's now pending application for permanent authority.
Commissioner Plant.
I agree with the recommendation.
Commissioner Gilman.
I also agree.
As do I, and that can be an ABC decision granting the motion. So thank you, Ms. Harper. Proceeding number 24AL-0130TR Mountain View Sports, Mr. Gramlich.
Yes, good morning. I'm Gary Gramlich of the transportation staff. This is an advice letter and tariff is filed by Mountain View Sports. They're based in Dillon, Colorado. It was filed on March 19th to become effective on May 15th. Mountain View Sports may transport passengers in shuttle service between points in Summit County. What they do is transport passengers from locations in Dillon and Frisco to the top of Vail Pass. They also operate a ski and bicycle rental shop in Dillon. They've operated the certificate since 2005. The manager did provide a brief summary of what they do, and they said they've been doing this for 20 years, and they also operate under a U.S. Forest Service permit, which allows the operation from May 15th through October 15th. They state they operate with one vehicle and 3 to 5 employees, depending on the ridership, and this transportation service is a small portion of the company's total business, only about 6%, but it does provide employment for 3 to 5 individuals throughout the summer months. The fares to Vail Pass from Frisco are increased to one way's 30 and the round trip is 40. From Dillon, it's again, the one way is 30 and the round trip is 36. They don't transport a large number of passengers. In 2022, it was approximately 1,500, and in 23, it was just under 1,000. So the revenue is not that large at $30 to $40 per passenger. The manager also states that the fare hasn't been increased since 2005, partially due that they would change the bike rental charge rather than the transportation charge. But with the increase of the fuel, insurance, and wages, they decided it was necessary to increase the transportation charges. Also, I did check, there's another company, they operate in Breckenridge, which provides the same service and has a certificate from the PUC to provide the service to Vail Pass, and they transport approximately the same number of passengers, and their one-way fare is also $30 to the top of Vail Pass, where the passengers ride their bicycles down to the base of the Vail Pass Trail, which I think it has a stop in Frisco and one farther down, but it's 12 to 14 miles. Not surprisingly, the demand for this service is to the top of Vail Pass so they can ride down, rather than to the base of the pass so they can ride up to the top. So they have been doing this for many years. There are other companies that do it also in the Breckenridge, Dillon area, and I do have a recommendation.
If you can make a recommendation, that'd be great.
It would be to allow the proposed changes to become effective by operation of law on the date in the filing, which is May 15th.
Commissioner Plant,
I agree with the recommendation.
Commissioner Goman,
I also agree.
as do I. Thank you, Mr. Gramlich.
Yeah. Mhm.
Proceeding 24A-0076R, Mr. DeCenso, Cottonwood Land and Farms, City of Fort Collins, Larimer County.
Good morning, Commissioners. Mitchell DeCenzo of your Commission Council. This matter comes before the Commissioners to address the application for a rehearing, reargument, or reconsideration to decision number C24-0207, filed by Cottonwood Land and Farms, LLC on April 23rd, 2024. Fort Collins and Larimer County, the joint applicants, filed a motion for leave to respond to Cottonwood's RRR, and Cottonwood filed a response to their motion for leave to respond. However, Council recommends that the Commission can reach its decision based solely on the merits of the RRR itself and can determine how to best handle these subsequent filings after addressing Cottonwood's RRR. For context, this proceeding concerns an application filed by the City of Fort Collins and Larimer County requesting the authority to change a crossing in Larimer County from a private crossing to a public crossing, as well as the authority to widen the crossing at the railroad. Cottonwood filed a notice of intervention, but did not include an explicit statement of opposition or request to hearing. As a result, the Commission concluded the application was uncontested. Based on that finding, the Commission decided to deem the application complete, allowed Cottonwood to permissively intervene, and granted the application without a hearing pursuant to Commission Rule 1403. In its application for RRR, Cottonwood states that it has safety concerns and asks the Commission to reconsider its finding that the application is unopposed. Cottonwood's safety concerns involve its intention to use a mining permit as successor operator, which it claims will involve heavy machinery and the movement of heavy hauling trucks on land adjacent to the trail and crossing described in the application. Cottonwood also asserts that its intervention, if read fairly and clearly in its entirety, expressed a desire to engage with the application and did not intend to merely monitor the proceeding. Additionally, Cottonwood argues that it had not yet fully formed its posture toward the application at the time of its intervention, but rather intended to avail itself of the process and rights afforded by its intervention. I can pause here for your discussion and proceed to offering a recommendation.
If you could give us a recommendation, that'd be great.
Council recommends denying Cottonwood's RRR. The rules governing interventions are clear. Commission Rule 1403 1A states that if a person wishes to intervene and to request a hearing, that person's intervention must state that the application or petition is contested or opposed, must give the reason why the application or petition is contested or opposed, and must explicitly request a hearing. Similarly, Rule 1403B states that a proceeding will not be considered contested or opposed unless an intervention has been filed that contains a clear statement specifying the grounds on which the proceeding is contested or opposed. Cottonwood's intervention failed to meet all of these basic requirements. Cottonwood did not include a clear statement that the application is contested or opposed, a reason why the application is contested or opposed, or an explicit request for a hearing. Given the absence of these requirements, the Commission deemed the application unopposed and granted it without a hearing. The Commission cannot infer parties' intentions and reasonably concluded that Cottonwood wished to intervene for purposes other than opposing the application and participating in a hearing, such as monitoring the proceeding. We also did not see merit in Cottonwood's explanation that the ambivalent statements in its intervention are because it had not yet fully formed its posture toward the application. That is not how the Commission's processes work. The Commission needs to know parties' positions at the beginning of the case so that it can know whether to expend the administrative resources to go through a fully adjudicated process. Additionally, the application was filed on February 12th, 2024, nearly 3 months ago, and it would be prejudicial to the joint applicants to mandate a hearing take place at this point. Accordingly, the Council recommends denying Cottonwood's RRR. If you accept this recommendation, then Council also recommends denying both Fort Collins and Larimer County's motion for leave to respond to the RRR, and Cottonwood's response is moot since the RRR is denied.
Commissioner Plant,
I agree with the recommendation.
Commissioner Goman,
I also agree.
as do I, and that can be an ABC order consistent with your recommendation. So thank you, Mr. DeCenzo.
Thank you.
Proceeding number 23A-0242E, Public Service Company of Colorado, TAP, Ms. Dundas.
Good morning, Commissioners. Lindsay Dundas of your Commission Council. In this proceeding, staff filed a motion yesterday for leave to respond to CEO's RRR request, and staff also requested a waiver of response time in its motion. In this proceeding, through decision number C-230224, issued on April 10th, the Commission considered the application of public service to approve its TEP. The Commission received numerous RRRs pursuant to 46-114, and typically responses are not allowed to RRR filings. However, staff filed its motion requesting leave to respond because it states that the requirements of Rule 1506 have been met, and that CEO's RRR should be, parts of CEO's RRR should be stricken because it attempts to introduce facts not in evidence in its RRR filing and also improperly raises new recommendations too late in the proceeding. For a decision today is not the substance of staff's motion, but whether to shorten response time so that the motion, any responses in the RRRs can be decided together. For context, the RRRs must be decided by May 30th, pursuant to 46-114. Would you like a recommendation?
We would.
Great. Advisors and council think a response from CEO or others may be helpful to help understand staff's motion. So we'd suggest shortening response time to staff's motion to 5 p.m. on May 15th, and that would allow us to have enough time to consider it before deliberating on the RRRs.
Commissioner Plant,
I agree with the recommendation.
Commissioner Goman,
I also agree.
as do I, and that can be an ABC order, shortening response time consistent with your recommendation. So thank you, Ms. Dundas. Let's skip the clean heat plan for now and move on to proceeding number 23F-0248G, Symmetry Energy Solutions versus Public Service Company. Mr. Sarah, Mr. Foreman.
Yeah, good morning, Commissioners. This is a complaint proceeding filed by one of Public Service Company's gas transportation customers, Symmetry. Symmetry's complaint alleges that the notice provided by Public Service for its Storm Uri proceeding, which you adjudicated some time ago, was constitutionally deficient, meaning that, at least with respect to Symmetry, the OFO penalty approved in the Uri proceeding wouldn't apply. Its complaint contains 3 other claims, all related to the Storm Uri proceeding and the penalty. 1 for breach of contract against Excel Energy Services and Excel, and 2 that argue that the OFO penalty is unjust and unreasonable due either to lack of notice or allegations that the penalty amount is incorrectly calculated. Public Service filed a motion to dismiss, which was granted by the ALJ's recommended decision. The ALJ concluded that Symmetry's due process rights had not been violated, that it could not raise a contractual claim before the commission, and that it was claim precluded from collaterally attacking the shipper penalties as unjust and unreasonable. On exceptions, Symmetry reiterates its due process and contractual arguments and asserts that it is not claim precluded because it wasn't in privity with any party in the Storm Uri proceeding. Public Service filed a response in support of the recommended decision. So I will walk through each of the exceptions and provide a recommendation for each of them. First, the due process claim. So Symmetry's due process argument is that it was owed personal prior notice of the Storm Uri proceeding under Colorado law. It argues that Public Service, by providing utility notice as prescribed by the Commission's decision that addressed Public Service's motion for alternative form of notice, was taking state action and therefore constitutional due process obligations attached to the act. Whether it was Public Service's notice that should be considered or the Commission's notice, the exceptions don't present an analysis under the established legal framework to analyze what process is due under any constitutional theory. Instead, the company relies on a provision of the state APA and one judicial opinion to support its contention. Neither stands for the proposition that Symmetry was owed personal notice of the Storm Uri proceeding. The APA provision Symmetry relies on is Section 24-4-105, subsection 2A, which provides that in general, agencies must provide personal notice of an adjudicatory hearing, provide notice of an adjudicatory hearing either personally or by mail, unless another law provides otherwise. And in this case, the utilities statute provide otherwise. Section 40-6-1082A governs application proceedings like the Storm Uri proceeding and requires that the Commission give notice of all applications to all persons the Commission believes are interested. But unlike the provisions in the APA, which specifically require personal or mailed service, the Commission's notice section doesn't require that notice be provided personally or by mail. The legislature understood how to require those types of notice and declined to require them for application proceedings at the PUC. The other source of law Symmetry relies on for this contention is Douglas County Board of Commissioners versus PUC, which is a Colorado Supreme Court case from 1992. I've reviewed the case at length. It doesn't stand for the proposition that personal notice is required in all quasi-judicial cases, and certainly not in this one. So whether or not Public Service was a state actor, Symmetry's argument that it was due personal notice of the Storm Uri proceeding is based on a misreading of the statutes and case law, and for that reason, I recommend that you reject it.
Commissioner Plant,
I agree with the recommendation.
Commissioner Goman,
I also agree.
as do I.
Symmetry also brings a contract claim, alleging that it has contracts in place with Excel that require Excel to notify Symmetry anytime Excel takes action at the Commission that would lead to tariff modifications affecting Symmetry. Symmetry alleges that Excel breached those contracts. That's fair enough, but the ALJ dismissed this claim because the Commission doesn't have jurisdiction over breach of contract claims. Those claims must be heard in a district court. In its exceptions, Symmetry argues that the Commission should hear the breach of contract claims because a judge in a related lawsuit dismissed a similar claim, finding that the PUC had jurisdiction. But Symmetry admits that it didn't actually present that district court with a breach of contract claim. It asserts the claim it did present, which was a declaratory judgment claim, was very similar. I recommend that you conclude the recommended decision was correct. The Commission doesn't have jurisdiction over breach of contract claims. Symmetry claims it now has a ripe breach of contract claim against Public Service. It can assert that in a court where jurisdiction is proper.
Commissioner Plant,
I agree with the recommendation.
Commissioner Goman,
I also agree.
as do I.
So the last 2 claims in Symmetry's complaint allege that the OFO penalty amount is unjust and unreasonable. 1, because Symmetry didn't have personal notice of the proceeding. And 2, because Public Service hasn't yet revisited the penalty amounts to ensure that the penalty calculations were accurate. The ALJ construed these claims as collateral attacks on the Storm Uri proceeding and analyzed them under a claim preclusion framework, finding that they satisfied the Colorado Supreme Court's claim preclusion test. Therefore, the ALJ therefore dismissed both claims as claim precluded. On exceptions, Symmetry argues that the ALJ erred in finding that claim preclusion applied to Symmetry's third and fourth claims because Symmetry wasn't in privity with any party in the Storm Uri proceeding. Symmetry claims the four-part claim preclusion test applied by the ALJ is not satisfied because the fourth prong, requiring each to be in privity with one another, doesn't describe Symmetry's relationship with public service. In its response, public service argues that Symmetry is in privity not with public service, but with the shippers involved in the Storm Uri proceeding, and therefore Symmetry's interests were adequately represented in the Storm Uri proceeding under a privity analysis. Public service asserts that for purposes of claim preclusion, what matters is whether another party shared legal interests, participated in the previous proceeding as a party, and according to public service, one shipper, Tiger Natural Gas, disputed the OFO penalties in that proceeding, and therefore shares sufficient legal interest with Symmetry for purposes of being in privity. I recommend that you agree that while Symmetry did have a contractual relationship with public service, and also had overlapping interests with a shipper in the proceeding, it wasn't in privity with any party to the Storm Uri proceeding. The doctrine of claim preclusion therefore can't be used to bar Symmetry's unjust and unreasonable charges claims, and therefore I recommend that you grant Symmetry's exceptions on this point.
Commissioner Flant,
I agree with the recommendation.
Commissioner Goodman,
I also agree.
as do I.
Now, it's important to remember that while claim preclusion may not apply here, parties have long been precluded from launching collateral attacks on final commission decisions. In this case, the Storm Uri proceeding has been final for more than a year. I recommend that you deny Symmetry's challenges to the ALJ's decision dismissing its third and fourth claims because both of those claims are collateral attacks on the Storm Uri proceeding. Section 46.112 sub 2 of the revised statutes precludes collateral attacks on final commission decisions. Symmetry argues that it should be permitted to collaterally attack the shipper penalties because it didn't have sufficient notice of the proceeding, didn't participate, and therefore it couldn't have appealed the commission's decision. But because you've concluded there was no notice deficiency, I recommend that you reject Symmetry's arguments and uphold the result of the ALJ's recommended decision dismissing claims 3 and 4.
Commissioner Plant,
I agree with the recommendation.
Commissioner Goodman,
I also agree.
as do I. And is there anything else, Mr. Acera?
No, that's it.
That can be an ABC decision, granting the exceptions in part and denying them in part. So thank you, sir.
Thank you.
Proceeding number 23M-0013 EG, Ms. Randall, the PIP program.
Yes, good morning, Commissioners. I'm Kelly Crandall with the advisory team, and I'm joined by Aaron McLaughlin from Commission Counsel. In 2022, the Colorado Energy Office, or CEO, began to engage stakeholders to prepare for a third-party evaluation of percentage of income payment plan, or PIP programs, pursuant to Rules 3412 and 4412K. Some customers may know these programs better as electric and gas affordability programs, and they provide bill reductions for income qualified customers. This evaluation process happens every 3 years, and this is the second cycle. So leading up to it, the Commission reviewed the statement of work and provided feedback at a Commissioners' information meeting in February. And then CEO and PUC staff selected GDS Associates as the vendor through a competitive process with the Commission's subsequent approval of the contract. On April 5th, CEO filed on behalf of GDS Associates the final report and recommendations, which I'll call the 2024 PIP Evaluation Report. GDS Associates used in-depth interviews, research on other programs, analysis of de-identified participant data, online and written surveys, and focus groups to develop its findings and recommendations. So notably, they found that the Colorado utility PIP programs do tend to be in line with practices used in other states, such as around eligibility levels and the paired model of offering both ongoing bill support and arrearage forgiveness. And I wanted to add, focus groups with the PIP participants provided really high praise for the program. People said that the PIP, among other assistance programs, made their bills easier to pay and supported them to pay for food, medicine, and unexpected expenses like car repairs. GDS Associates also identified some areas for further exploration to improve program performance, such as identifying a potential gap between customers who may be eligible and those who are participating, and variations in how utilities are implementing PIP programs in areas like specifically how they're calculating arrearage forgiveness and benefits. And they also looked at demographic and other information on program participation and found some correlations in areas like customers with disabilities and the housing types of participants. So finally, GDS Associates provided some recommendations on how to make the audit process itself run more smoothly, including setting clearer and more specific expectations and timelines for data retention and transfer, consolidating various contract vehicles, and creating program manuals that describe utility-specific practices. So as I previously noted, CEO filed the 2024 PIP evaluation report on April 5th. And so the issue before you all today is whether to take any initial next steps on that report. And I can make a recommendation or take questions.
Yeah, why don't you make your recommendation, and then we'll come back with questions, comments, and next steps.
Great, thank you. So I recommend the Commission acknowledge the 2024 PIP evaluation report and issue a decision seeking stakeholder comment on at least the following questions. First, what recommendations in the report should be the highest priority for the Commission to implement or the lowest priority? Second, is there any clarifying information utilities would like to provide about how their PIP programs are managed or implemented? Third, are there any recommendations for improving utility PIP programs you think that stakeholders think are missing? Fourth, what recommendations is the Commission best positioned to implement, and what recommendations may be relevant for other stakeholders to implement? And if there are recommendations that are already underway in implementation. Fifth, are there activities that can make the evaluation process more effective, such as consolidating non-disclosure agreements, setting clearer data request processes, or narrowing the scope? And sixth, if the Commission were to encourage or require utilities to develop program manuals for implementing PIP programs, which is consistent with the GDS recommendations, then what content could be included in those manuals? And I think this will lead to valuable information to prioritize and clarify the recommendations in the report. Although given the length of the report, I'd recommend setting a deadline of June 5th for initial comments and June 19th for responsive comments. And following the receipt, we could return to you all with appropriate next steps, which could range from hosting a future CIM or workshop to closing the proceeding and moving into a rulemaking process. And just lastly, I wanted to note the timing of this, I think, works well, such that staff will be developing a capstone report in the equity proceeding, proceeding 22M-0171 all, that is being led by Commissioner Gilman. And so that'll be coming in at the end of June. And so we think there's some opportunities to coordinate some of the next steps out of these processes and to, as we move into a rulemaking process, and to connect some of the recommendations on energy assistance and equity.
Well, thanks so much for the report and your leadership on these issues, and glad to hear our PIP programs appear to be national best practice or close to it. Just one question from me, and then look forward to hearing from my colleagues. But I know we disconnected over 6,000, permanently disconnected 6,000 customers in 2023. Do you have any thoughts on how we link those customers to what's going on the PIP program, or sort of better understand the relationship between an overlap between the two universes of customers?
Yeah, you graciously let me think on this question overnight. So I do have a few thoughts on this. So right now there are three major paths to get into energy assistance if someone's at risk of not being able to pay their bill. So you have winter heating assistance for applying through the Low-Income Energy Assistance Program, LEAP. There's also the Energy Office Weatherization Assistance Program, which is more on weatherization and building upgrades. And then Energy Outreach Colorado has emergency support. If somebody's late on their bills, they're at risk of disconnection, they can go to EOC. And more recently, the PUC itself has been piloting a program called Utility Bill Help, which is connecting people who have been rejected from LEAP or not finished the application process, but have applied for and received other state programs in Department of Health and Human Services, and connecting them directly into PIP. So GDS had come up with some areas for improvement here. They were looking at whether the PIP program has a statistically significant effect on reducing disconnections. And that's now been a component of the evaluations. And I think there's some indication that it does create a benefit, but not all of the utilities have relevant customer specific data to make these connections. So there seems to be a gap in being able to do this kind of longitudinal analysis and like make the connection over time. You know, are people calling in for assistance? Do they are they persistently in arrears, and therefore might they be a candidate? And I think so. This seems like, I think you're referring to what is kind of emerging in some other states in looking for these non-traditional metrics besides income verification to see if somebody could benefit from assistance. So there was a process resulting from the COVID-19 pandemic at the New York Public Service Commission to look at bill forgiveness for customers who not only had been part of a program like LEAP, but also had called in repeatedly for assistance or had particular arrearage patterns or things like that, but maybe hadn't gone through all of the specific steps to get into other programs. And so there are some ways that people are starting to think about these as proxies to get involved. And I think that's the kind of thing that could have a lot of merit in the future. I don't think we're quite set up to do that in Colorado now, but we are finding this is now the second PIP evaluation report. We found that in both of them, that there is likely more need for assistance than is reflected in current participation levels. And there's also feedback coming in from these focus groups and surveys that people are having trouble enrolling in various programs. And that's for a range of reasons. It could be challenges getting through some of the paperwork and meeting, you know, if people have multiple different jobs with different entities, they may have different kinds of income paperwork they have to collect and submit. There could be lack of clarity around who to call first and how to get to the actual implementer to fill out the paperwork. People who don't speak English as a primary language and so forth. So I think this is going to be a multi-step process to do the kind of thing you're talking about, and looking at both the information gaps we have, and then also thinking about what's the most effective process to get people enrolled in assistance. Because I think there could be processes that rely on better data use, and then there could be other processes that involve more investment in like navigators and trusted partners to help people to get to the right place at the right time. And I think there's a lot of work going on already with utilities and agencies and service providers to try to streamline this process, but we do still have a long ways to go, even in areas like ensuring that somebody who participates in a benefit program at one state agency is able to participate in all the other benefit programs offered by that entity, and much less, you know, making those connections across different service providers. So I know that was kind of a long-winded answer, but I think this is a really nuanced subject, and it's an area that could be fruitful for continued discussion.
Yeah, if you could just over time keep pounding away both at the data and ways we can improve. You know, of those 6,000 people, I don't know how many were enrolled in PIP or LEAP or other programs. So even just, you know, the basic data would be helpful. Commissioner Plant, questions, comments? And I guess we're taking a vote.
Yeah. Well, first of all, I support the recommendation. And I similar to you, Mr. Chairman, I was really pleased to see the level of satisfaction with the PIP program for those who have been able to enroll. I think it's a reflection that if people can get into the program it's a really successful program. One of my concerns is the ability of people to get into the program. And along those lines, I'd be interested in getting some either case studies of people's individual situations, or an example of the consumer experience in enrolling in various programs. I mean, there's a number of these assistance programs are all great programs, but they have different levels of qualification, whether it's maybe a percentage of AMI or it might be a percentage of the federal poverty level. They're operated by different agencies. They're operated by different entities. They have different enrollment procedures. And, for the consumer, that can be a really daunting thing. Particularly if the outreach is from the utility to the consumer, and then the consumer needs to get back in touch with the utility in order to chase down, the right person to talk to for various programs. And I'm wondering if there's opportunities for us to really centralize the consumer experience, preferably with entities with whom those customers are already engaging. For example, like maybe the county human services programs, or I'm not sure what the exact pathway or avenue would be, but really something that would help to streamline the consumer experience and assist them in getting enrolled in the programs that they would be qualified for. I think it's a real barrier for people. It can be really demoralizing when you try and chase down, one lead on one program, and you end up, sort of not being able to figure out who to talk to or where to go. And then you just kind of drop the ball on everything else, because these are people who are generally pretty busy, and don't have a lot of free time to chase down this kind of thing. So I would be really interested in trying to pursue what the customer experience is in ways in which we can try and streamline and assist in that. And, honestly, some of this might be outside of, our purview. I mean, we're, clearly dealing with the utility program side of this, and there are a variety of different programs from a variety of different agencies and entry points. But anything that we can do to try and maybe identify where it can be facilitated and where it can be streamlined, I think that would be helpful to the process.
Any comments, Ms. Crandall?
Thank you. That's certainly advice I'm happy to take back, or direction I'm happy to take back. And as we're looking through comments and working on next steps, identify some options for that, and kind of what would make the most sense for the PUC to be most specifically involved in. Were you looking to add to any of the questions for folks, or more just consider that as next steps?
I think, to the extent that any of the people who are submitting information could provide us with any information they might have around a customer experience or barriers that they see to customer enrollment, ease of enrollment, I think that would be helpful. And I don't know if it was a part of your recommendation, but I would support the SIM that you mentioned as well.
Yeah, I think that will be, I'll bring back more specifics on that and some options to see if that's something that you all want to pursue in the future on the CIM. But if it's all right with you all, I could add some language to the decision on welcoming comments on barriers to enrollment and improving customer experience.
Yeah, that'd be great. Commissioner Gilman.
Yeah, thanks, Ms. Crandall. Yeah, along those lines, I had somewhat similar reaction. It's a relief to understand and see that the programs appear to be working pretty well, with fairly high satisfaction for those who are enrolled and are taking advantage of the programs. Yet the programs are still reaching what appears to be a pretty relatively small percentage of eligible customers. And so I think really understanding those barriers to get in, what gauntlet do customers actually face as they're trying, as Commissioner Plant was discussing, to get into a program, you know, and how understandable and approachable is the process, is an important part of this. And as part of this, I really want to point out the implications of being income qualified here. It's not just getting in the PIP program or getting LEAP support, but potentially also ties to programmatic spending and rebates that could be available in a number of programs, which is an area of emerging focus, and I think with considerable potential benefit to customers, especially as we've talked in Clean Heat, and we'll probably talk again, the next agenda item, about the importance of really focusing some of that support, you know, a good amount of that support on IQ customers. So I'd point out, this goes beyond just bill assistance in terms of really kind of the full ecosystem of support that's available to those customers. And so, Ms. Crandall, perhaps something to look at, and you tell me if you think it's reasonable to put this in a question, in terms of the touch points where customers could learn or become more aware of their ability to qualify as income qualified, it's a potential that some of those rebate programs, whether it's transportation electrification or DSM or beneficial electrification, might be avenues for the customers to also understand that. They will see, I get an enhanced rebate if I qualify for this. Well, what is that? And so there should be some linkage as they're in materials or in access as they're learning about those programs, and that could be another way that customers understand that there is this designation and kind of begin their journey to understand if they can qualify and apply. Just the more we focus on IQ across programs, the more important it is that we ensure we're really getting the folks that are eligible in the programs. They can take advantage not just of the PIP, but also those rebates. So I have one other thing, but maybe I'll just give you a minute to react to that if you had anything.
Yeah, thank you, Commissioner. And I think I'm trying to think of how best to maybe frame this. If you're thinking of a question, if it would be something along the lines of the connection between energy programs and bill assistance, and kind of how customers are getting from one to the other.
Yeah, I think like it could be more of a two-way situation where that might be the first that they learn, you know, of becoming income qualified, because they're beginning to understand rebates in a program and see that there's a differentiation. So perhaps just as, you know, kind of an exploration of how this provides two-way communication for customers to also learn about the programs, as well as take advantage of the funding through these other programmatic avenues that tie to income qualification and PIP more generally.
I think that makes sense to me. If it's okay for all of you all, I can add a question to that effect. I think it would. So one thing that came out through the PIP evaluation, and I think we've seen this through rulemaking and so forth, is utilities do provide information to PIP participants about other energy programs they may qualify for. I think we don't necessarily have a strong sense of the opposite direction. If somebody starts looking at a program, when do they find out that they may qualify for other types of assistance and things like that? So that does seem like good information to understand better.
Yeah, thanks. Especially given the type of push I think we've discussed contemplating in some of these programmatic areas, this might be a really significant amount of outreach, especially to certain neighborhoods on availability, and this might pique people's interest and participation in a way we haven't seen yet. The other thing I wanted to just kind of inquire about and potentially propose a question on, Ms. Crandall, it seems to me that the PIP evaluation had some challenges with kind of access to data from the utilities, and perhaps the timeliness and comprehensiveness of the data, consistency. Is that maybe a fair assessment? And then perhaps a question to suggest from that after you respond to that.
Yeah, and I guess I would just note that there were some comments from GDS associates in the report that it might make sense to prepare ahead a little bit more in terms of what data might be expected and get a little clearer about what should be collected for what types of analyses to enable more effective tracking over the entire term of the evaluation process, and then be able to submit data faster and more easily. Yeah, absolutely.
Okay. Yeah, just a thought, as I think we've fairly consistently seen that the consistency, timeliness, and kind of forthrightness of data that really only the utility has, but that we need to truly understand the effectiveness of a lot of these kind of programs and situations is really a crucial part of targeting and deploying financial assistance. And so, we have an expectation, which you discussed, for an upcoming rulemaking as part of the 272 efforts, more broadly looking at equity and impacts, but a lot of the IQ issues tend to fold in there in a way. And so my concern in going forth with those efforts is really having a focus on getting consistent, timely, and fulsome data from the utilities when it's requested, understanding what data might be required in some of those. So I don't know, if we frame a question around this, but I'm interested in how the commission kind of structures access to that data in the future. And, if there are penalties or other actions that need to be taken if appropriate access to that data kind of frustrates our efforts in this area, because that makes a lot of this work more difficult.
Thank you, Commissioner. I'm again trying to think of how to best phrase that sort of question. So it would be,
Yeah.
Oh, go ahead.
No, I was going to say, do you think it would be helpful to have individual commenters provide listings of data that they think would be important to track, like in the future rulemaking? Or should we focus more, from what you've seen on this, on what are kind of the commission's tools if that data is not being provided in a timely and consistent way?
I think it would behoove the commission in thinking about future rules to figure out how specific or they want the actual data to be in rules, how prescriptive, versus whether it's the kind of thing that is negotiated out by a stakeholder process. I think we've seen both approaches, and sometimes one works better and sometimes the other works better. I think there can be meaningful differences in how utilities track information, such that sometimes there has to be a little bit of translating across entities to make sure you're getting the information that is useful to actually answer the question being posed. Let's see. I was thinking maybe a way to ask this is, well, one way to ask it is whether the commission should consider taking some of the GDS recommendations and structuring a process and deadlines for when data should be provided in the evaluation. And I think that might be just a more rigorous process for the evaluation itself. So more timing around, refining the statement of work, establishing a scope of the evaluation, setting up the data processes that would be involved in that. I do think there's some staffing things to think about that, but that could be a question. It sounds like your question is going a little more broadly in terms of thinking across both of these rulemakings. And so is it more in the vein of, when we have data intensive processes like this, should the commission be structuring them a little bit differently?
Yeah, I mean, maybe it's not ripe for an exact question in this order, which is fine. But just want to express, this is not the first time we've seen a concern kind of with the timeliness and and consistency of data. And I know you and your team have done a lot of great work, especially on the disconnection data and stuff, to really fight through a lot of data to try and get it consistent and to make sense across utilities. So, maybe more just a discussion that, this is an area that potentially could frustrate a lot of these efforts, and we really need to make great strides to ensure, that in that future rulemaking, we're doing the best we can to position ourselves to have kind of timely and consistent data across the utilities so we can understand what success looks like, what would we measure, and then how do we continue to move in that direction and get relevant reporting.
So perhaps something along the lines of welcoming comments on how to improve the process of getting to meaningful and consistent reporting when we're getting into something that's really data intensive on programmatic issues.
I think that's reasonable. Yeah, I mean, it is fairly general because I think as we see these processes probably somewhat fold together in the future in a rulemaking, I think this is going to come up, and I think it could plague us if we don't make some headway on really what tools we have available to make this part of the process work better.
And so I think across all of you all, what I've heard is some modifications to the original recommendation to include some of these concepts around better understanding disconnection and opportunities to target program assistance, welcoming comments on barriers to enrollment and improving the customer experience, looking at kind of the two-way communication of how people are getting into energy programs and energy assistance and where the referrals are between those, and looking at, welcoming comments on improving the process of getting to meaningful and consistent and timely reporting for programmatic and other issues.
And unless you have concerns, Ms. Crandall, I think this should probably be a TBC decision.
I
guess it does screw up the timing of the reply comments. I don't know. What do you think?
I can do it either way. I'm comfortable. I can reflect what you all talked about, but I'm also happy to do it TBC, and perhaps we just modify the recommendation to 4 weeks and 2 weeks on the dates.
Is there any other deadline on the back end?
No, I think primarily I was thinking of some ways to have comments be coming in as we're thinking of the staff capstone report in the proceeding 272 or the proceeding on Senate Bill 272, recognizing that they are two different proceedings, but there are some future things that could be coordinated.
Commissioner Plant, Commissioner Goman, any thoughts, TBC versus ABC?
I mean, I'm okay either way. I mean, nice to review it, but I don't think it's necessary as far as I'm concerned. It's particularly if it messes up any timing, but.
Commissioner Goman?
Yeah, I mean, I'm fine with it being ABC. I'm confident Mr. Crandall can reflect what we've discussed. If you want it to be TBC, I don't think it's a big concern, but it's probably ideal the sooner it gets in rather than later, for the staff to be able to incorporate, anything relevant in that capstone report on 272.
Let's do it ABC, Ms. Crandall, and thank you for your leadership and driving this forward.
Yeah, greatly appreciate it. Thank you, commissioners.
Thank you. Back to proceeding number 23A-0392 EG, Mr. Mendelson, Ms. Dundas, Public Service Company, Clean Heat Plan. Continue.
Of your advisory staff. I'm joined by my colleagues, Dan Greenberg, Michael Eden, and Jessica Shula, as well as Commission Counsel Lindsay Dundas, Wendy Rosati, and Ruthie Harper. This is the third deliberation for Public Services Clean Heat Plan application. In the first deliberation, the Commission agreed, among other things, to reject hydrogen and greatly limit recovered methane as part of Article 1 Clean Heat Resources until more information is available. You also agreed to go above the cost cap, rejected the company's scalar mechanism, and rejected its constraint on AC replacements alone and adopted that as a prioritized BE pathway. In the second deliberation, we ruled on most items related to verticals 2 and 3, the market transformation portfolio, and emission reductions of ongoing throughput. Today, we have a few cleanup items in each of those areas, followed by the gas consumption forecast. Then I will discuss where we are with the current budget using the Flex Base Plan as a starting point. I'll also describe the rate impact evaluation Chair Blank asked advisors to conduct. Then I'll ask for your perspective on final BE and DSM budgets where the bulk of the CHP spending will take place. Then we'll review SEAMS issues, cost recovery components, and various logistics related to the regulatory pathway. If necessary, we'll return to the budget finalization and emission reduction expectation at the end. We likely will need the deliberations at the next CWM on May 15th to finish. So with that, I will turn it over to Mr. Greenberg.
Good morning, Commissioners. Dan Greenberg of your advisory staff. And as Mr. Mendelson said, just a few cleanup issues on the market transformation portfolio. And first, regarding the neighborhood residential retrofit initiative. You all agreed at the May 3rd deliberation that you want to strongly encourage the company to integrate this initiative with the Aurora F3 NPA initiative. The budget for this initiative is $10 million, whereas that for the Aurora NPA is $7.5 million. Presumably, if the retrofit initiative is integrated with the NPA, there should be some overall budget reduction, but we have no record indicating what budget reduction might be possible. So the first decision point is whether or not you wish to include any language in the decision regarding the aggregate budget if these two initiatives are combined.
Commissioner Goman, I think you raised this. What's your thought?
Yeah, I mean, it makes quite a bit of sense to me that this should be integrated within an NPA area. First of all, that provides the most immediate, potential benefits and impact. The second thing I'm a little concerned about is there are a lot of initiatives proposed here, especially within the MTP portfolio, and a pretty huge expansion in what we're talking about in existing, BE and DSM programming. And so I worry also about kind of the distraction factor of having all this go on. To me, I think the NPA is a major priority and pretty much encapsulates this type of work, of outreach, and end result aligns incredibly well with what a neighborhood residential retrofit would look like. Understanding, perhaps your control group moves to a neighboring area or something, I think relatively not a big deal. The weather's quite similar, housing stock could be quite similar. So for me, it makes a lot of sense to see this integration. I don't understand at the onset the exact impact that would have to the budget. Understandably, potentially that neighborhood residential retrofit could include some data reporting and things that an NPA wouldn't, like comparison to a control group and some of that data collection. But to me, this seems like a pretty obvious efficiency we should find, not the least of which because I want the company to be able to really concentrate their efforts. And this seems like a really reasonable way. And then I think Commissioner Plant had maybe made the point on a VPP connection here that are in the new construction. And it certainly makes sense to be thinking about, like, I don't want to frustrate or slow down the efforts by making it too complicated, but it certainly makes sense that, if you're getting a high density of new, highly controllable, electric loads in a certain location, that's pretty ripe for demand response and VPP integration. And that's something the company should be thinking of, honestly, because it's an obvious relationship there in terms of efficiencies. So I don't know your all thoughts on, is this recommending integration, requiring integration? To me, I'm just worried if we have all these extra efforts, we distract ourselves from the most important. I think also integrating these efforts where the neighborhood residential retrofit is focused primarily on electrification could get to some of the stakeholders' concerns about the amount of new gas equipment that was proposed in the original Aurora NPA. Whereas instead of going so far to say you can't have gas equipment, perhaps by overlaying the neighborhood residential retrofit electrification, we just end up with a much higher percentage electrification, than equipment by virtue of kind of overlaying that and focusing on that so much in that area. So any thoughts, I'd be happy to hear.
Yeah, so it sounds to me like we'll put some language in the decision talking about the synergies of combining the residential retrofit program with this one specific NPA, strongly encouraging the company to integrate those two efforts with the hope that there's some budget saving and with a request to see if we can focus a VPP program on the the greater electrification. So I don't know, Commissioner Plant, would you say any of that differently based on what you heard from Commissioner Gilman and I?
No, I think the strongly encouraging sort of language. I mean, we do want to try and combine these efforts if at all possible. And as it relates to the VPP issue, I think it's a really good opportunity to sort of look into implementation of that phase 2 approach that we've asked the company to pursue. That's looking at the benefits in the distribution system, which, as Commissioner Gilman pointed out, really requires a high density within a transformer or a feeder of manageable participants in that specific feeder. So I think it gives you an opportunity to start to test some of those things, and I think that the time frame of this kind of aligns pretty well with the time frame that the company would be coming in with their phase 2 proposal as well. So I would think that approach would make sense, but it's in terms of, Mr. Greenberg asked about, specifically like sort of how to adjust the budget. I'm not really sure. I mean, there's cost savings and
Yeah, it's up to the company. We're approving a total budget and the rest has to be figured out later. So I think it's just some language saying we hope there's savings there and there's great sense in integrating the two. So hopefully that gives you what you need, Mr. Greenberg.
It does, thank you. I will move on. The next initiative is the all-electric new construction initiative. At the May 3rd deliberation, there was consensus that the new construction represents some of the lowest hanging fruit for beneficial electrification. And Chair Blank suggested increasing the budget and expectations for this initiative by a factor of 5 to 10. So the first question for your deliberation on this initiative is whether and to what extent to increase this initiative's budgets and goals.
So I think it was a $5 million budget. I'd suggest increasing it by a factor of 6 to 30 million. I don't, I mean, it's like, again, we'll need to provide flexibility. I don't know how to ramp it, but, just really disappointing and, hundreds of, $500 million plus set of budgets ramping greatly, that the most cost effective, lowest hanging fruit in my view is limited to a pilot. So I don't know, Commissioner Plant, you're okay with something like that or want to suggest a different number?
Yeah, I mean, when I was looking at it, one of the things I was thinking, and you can tell me if this works with what you're thinking or not, but I really, first of all, I really like the idea of, just amping up that budget and trying to really take advantage of that opportunity to the greatest extent possible. I think when I was sort of incorporating it into, trying to come up with a 24 to 28 budget, I just multiplied times 5x for the 24, 25, 26 period, and then leave the rest to the flex adjustment at that review. So if there had been real success and we were seeing, that pilot program was really, had been successful, we could put more or see where the budget is at that flex period. But again, we haven't really talked about the flex period, so I don't know if that fits in with what you guys are thinking or not.
Commissioner Gilman, any comments, thoughts?
No, I think this is I think it's reasonable to increase the size of that budget. Of course, just I mean, if you compare to the retrofit cost, if you compare to anything, I mean, it's pretty clear the most cost-effective carbon reductions we can get on this system is primarily not adding any more carbon to the system to start with. So the avoidance of new construction, adding to the carbon load of the LDC system is a huge priority, and I think has been discussed here and in previous proceedings as the low-hanging fruit here. So, yeah, I mean, I think when we get into the broader discussion on budget, I'm looking at kind of reallocating some of the funds. So, I'm comfortable with 30 to 40 million in extra funding from some of the areas we have not approved to go here, some of it into the flex, so it'll make more sense probably later when we talk about the full budget. But I'm very supportive of moving in that direction. And I think we should certainly identify in the decision the unique potential to look at ground source options, especially networked ground source options in new construction, especially new entire developments. I know there's a separate initiative related to that, but as I've mentioned already, there's a lot of initiatives here, and some of them serve somewhat the same purpose, and where the company can find efficiencies in linking them together. Like, for example, if you have an entire, greenfield or area of new development, that could be a prime target to look at network geo, as a pilot or as a program to run in that area. So I wouldn't require it, but just suggest that there are really useful efficiencies here to look at some of the other things they hope to learn and look into as it overlaps with this. And now, I think an enhanced budget in this area to support kind of more fulsome. Also, as we discussed last time, Chair Blank, I'd want to mention in the decision as well that our expectation with an enhanced budget is also to ensure that we have kind of more diverse data here in the collection. So rather than just looking at one developer, one geographic area, one pool of subcontractors in a geographic area, that this really allows it to spread to multiple areas that may have different climates, different contractor pools, different access, and to really understand kind of the unique challenges and benefits with regard to new construction that could span across several different geographic areas. So we really get the best information possible through this pilot. So that's something I think would be very helpful to highlight in the decision as we talk about the expanded budget for this effort.
I strongly support the inclusion of that language and requests. Commissioner Plant, did you have something to add?
Yeah, no, I mean, I agree with everything Commissioner Gilman said. I think that one of the other aspects that it would be good for the company to look at is, opportunities as they're moving away from, the gas LDC system in these all electric new neighborhoods, whether or not there is an opportunity for them to shift to network geothermal sort of infrastructure as a component of company assets that would deliver clean heat for those neighborhoods.
Sounds good. Commissioner Gilman, did you have something to add?
No, I was just going to say I'm supportive of that. We've had this discussion on long-term rate impacts and how this looks as you draw it out, and those are largely an impact of reduced throughput on the system, which we've discussed looks to be the most cost-effective way to reduce carbon on the system. But what Commissioner Plant brings up is a good point. I mean, I've brought up kind of the labor relationship to looking at other options, like more ground source options. But also, I think there's kind of a rate base and a future of the business model aspect to it as well. That's probably worth bringing up here, in that, the projections that are worrisome, I think, about future rates are really based on, the reduction of throughput being something that's difficult for any business to sustain when you sell less stuff and your costs stay the same or go up. It paints a difficult picture for rates. However, I do think there are likely options available. We didn't see them, provided in any major way in this clean heat filing, but I certainly think it's something that the company could look to in the future in terms of heat as a service or network geo, options to really understand how could something like that work together with their existing regulated utility service to perhaps, kind of buttress the rate base and avoid some of the long-term rate impacts that could be worrisome if we rely only upon essentially the existing business model to move forward. So just relates to Commissioner Plant's point, and I thought was worth bringing up.
More to come on, on that discussion. Mr. Greenberg, anything else?
Well, I'm not sure I heard consensus on a budget number for increasing the budget for this initiative.
Yeah. I mean, it's somewhere between 30 and 40, but it depends on the broader DSM budget, probably consistent with the comments Commissioner Plant had about, ramping it up as a percentage of 24 to 26 and then seeing what we do after that. So I don't think we can go further until we have the broader budget discussion.
Okay. And then lastly on this, I just wanted to see if there was any interest in conversation about the potential tie-in of this initiative with the virtual power plant process.
I mean, I think we're going to do what we did on the residential retrofit, which is just have some language encouraging them to look hard at how they can use the virtual power plants in a new construction program to, manage down the electric side costs. So I just think it's encouragement language like we did in the retrofit. So unless Commissioner Plant or Commissioner Gilman have other things to add to that.
I think it's fine to use encouragement language, but for me, I think it would be appropriate in the decision to point out an obvious connection and benefit in linking these programs that the company should avail themselves of to ensure that we're minimizing future costs for ratepayers.
Yeah, I agree. I don't know if we need to, say that, a portion of the budget that's approved could be used for, that sort of integration, or if we want to say a certain amount of the budget. I don't know how specific we need to get there. Not to exceed or whatever language.
Well, let's get through the whole budget discussion and then come back if we want to do anything.
And I'm assuming this is going to be a TBC decision. So, I think I could suggest some wording along those lines that you can either stick with or modify to your liking. All right, moving on to the coal bed methane initiative. At the May 3rd deliberation, you agreed not to make a recommendation to the legislature regarding whether this resource should be considered a form of recovered methane, but that if that change is made, the company should treat it like any other form of RM, and that it would be subject to the same decisions you made regarding RM at the May 1st weekly meeting. You also noted that the record has few details about this resource, such as the duration of contracts, the need for any new infrastructure to connect it with the distribution system, and whether the costs the company has presented are all-in costs of this resource. You agreed that it's premature to approve this project without this additional information. So given that decision, is there any information in addition to what I just mentioned? So duration of contracts, need for infrastructure, whether additional infrastructure or whether costs in the record are all-in costs that you want to specify, any additional needs for information about this resource?
Commissioner Plant.
I don't have anything to add to that.
I don't either. Commissioner Gilman.
So to me, I think this is the same as what you described, Mr. Greenberg, but we'll check. If there is a statutory change that would permit coal bed methane from being included in the recovered methane protocols as well, then the company could provide this project in a 90 day process similar to other recovered methane projects for specific approval as we designated in the recovered methane kind of subset entirely. Is that jive with what you said? I think we're talking the same thing.
That is accurate. I just want to point out that that information does not come to you unless staff files a notice of deficiency about it.
Yeah, I'm fine with that. The only kind of clarification I would make is we had a longer, more fulsome list in the recovered methane discussion in terms of greenhouse gas impacts and like other totality of information. To me, it's that list of information. It's the same process. Considering it be approved, it's the same process. It's the same information that we already went over for recovered methane. So to me, I think that would be the cleanest and most consistent process, is to use that existing set of information already.
I'm fine with that, Commissioner Plant.
Yeah.
All right. Okay, so another question, and you just referred to it, is the process to consider the additional information. Are you comfortable reviewing this additional information using the 60-day notification process, or do you want to bring it up during the flex process or some other process?
Commissioner Plant?
Yeah, I mean, in my mind, we're talking about these as separate issues, but in my mind, they're the same as recovered methane. I mean, the recovered methane process that we talked about applies to, statutorily approved recovered methane processes. If this becomes one, then it falls into that same process that we talked about with the CEO list of, process. So I think it's just treated that same way. It doesn't need to come back to us if it's a legislatively approved process. And then in terms of, the flex time period, I just see that as a reallocation of budget for the final 2 years, and based on, what the performance of the various different programs has been, so that we can adjust at that time. So I don't think we reconsider, these specific methane projects at that time or anything.
Does that work for you, Commissioner Gilman?
Yeah, I agree. I think, given the guardrails we've already put around the recovered methane situation with the 90 day process and the $10 million budget there, I think this nests in there. If that's a project that they pursue, I'm comfortable with the 90 day process as it's already been laid out, which does not necessarily automatically come to the commission as the decision makers as an avenue to get this resource used as a recovered methane source pending approval and their pursuit of it in a 90 day process. So to me, it's a recovered methane source potentially, if they get that legislative change and would follow the same process. And I am comfortable with that within the budget that we've already set for that resource type.
Does that give you what you need, Mr. Greenberg?
It does. I just would ask you, Chair Blank and Commissioner Plant, if you agree with Commissioner Gilman that if it does become a qualified recovered methane resource, that it would fall within the same $10 million budget for recovered methane.
Yes.
All right. Finally, if it's not deemed, if coal bed methane is not deemed a recovered methane resource by the legislature, do you want to include in decision language encouraging the company to consider seeking approval of this resource in a voluntary program to be considered in a separate process?
Commissioner Plant?
I think, Mr. Chairman, I think you brought up sort of an idea for a voluntary program, which I don't know if that needs to be considered separately from this process, or whether this recovered methane resource might be a component of what you're proposing.
Yeah, I think I'd just take it up in a separate application. So I don't know that there's anything we should be doing here. Commissioner Goman?
Yeah, I'm not prepared. I think it's an interesting idea to kind of expand the universe and think through out loud what things might look like in the future, but I'm not prepared to endorse that like in a decision, especially since I don't understand the greenhouse gas implications through like an approved protocol or anything like that. It would be very difficult to endorse and understand the actual greenhouse gas impact and costs associated with that in order to suggest it be part of that offering.
Does that give you what you need, Mr. Greenberg?
Yes, I think it does. I just want to check in with Commissioner Plant's position on that.
Yes, I agree.
Okay. All right, then finally, certified natural gas. You all agreed that CNG is not a clean heat resource and that any related emission reductions would accrue to upstream and midstream suppliers. But two of you expressed at least openness to the possibility that this proposal could have some validity in reducing emissions from the company's gas throughput. Chairman Blank expressed interest in CNG as a component of a voluntary program in which participants would pay a premium to purchase a cleaner gas product, creating some market pull that could convince some operators to invest in reducing the emissions of their operations. There are two decision points with regard to the proposed CNG initiative. First, do you wish to approve the requested $1 million budget, allowing the company to go ahead with this proof of concept project?
Commissioner Plant?
Well, I think they're maybe tied together how we want to go forward, or if we want to go forward within this proceeding on a voluntary product. And I don't know if you're thinking, Mr. Chairman, on the voluntary product was to ask the company to submit a separate a separate application for a voluntary product, or where we could sort of investigate all the various issues that came up with that. And if we do that, is there a need for a sort of some sort of budget for them to explore the potential of that market? I'm not sure.
Yeah, I think there's not much we can do here, and it's going to require a separate application. Commissioner Goman?
Yeah, I guess with regard to kind of the discrete point of any CNG spending in this budget, I'm not comfortable with what we have here to approve a budget there. Yes, people will continue to use natural gas for some time, and it would be great to have a lower footprint. However, that is in a different sector. It's in the oil and gas extraction sector rather than the distribution end use of gas. And there is an entire regulatory structure around what reduction should come from that sector and how they plan to get it. And I'm pretty entirely unclear on how the baselines that we have now, which we don't appear to have good calculations of, kind of relate to what necessarily would be done. So it's not clear to me that an investment here to drive the market, how that relates to investments the market will already be making to comply with mandatory regulations, and so that it's a bit bureaucratic to say, well, another department deals with that, but at the same time, it's very accurate that there's an entire structure around what is going to happen to emissions there that I don't think we have enough information about to make a decision to really understand, the baseline, or if we are in fact getting additional greenhouse gas reductions from any purchase in this. To me, if the pilot or demonstration, I think, answered the most pressing questions in the sector, that might look and feel different. To me, the most pressing questions are, what are really the most appropriate technologies to be verifying these emissions? What is the actual baseline? What will the baseline be or change, or what changes will we see based on regulations in that particular sector to reduce emissions? And how do we ensure kind of the validity of this data and following through? None of really those baseline or important questions, to me, this demonstration kind of hits at the heart at. So to me, it primarily sounds like a demonstration that we can spend extra money to purchase a product with some level of verification, yet the jury seems to be out on a lot of the other details here, which make it really difficult for me to understand how we would actually use data and how we would solve the main pressing questions about the use of this going forward. I think a lot of those things would just simply not be addressed by this process. So I kind of fail to see its use to us at this point without some of those foundational issues being much better understood and fleshed out, particularly in Colorado and in that sector.
Does that give you what you need, Mr. Greenberg?
I actually didn't hear your thoughts about this, Chair Blank. It sounds like Commissioner Gilman is opposed to the funding for the CNG pilot. Are you in the same position?
How it was, what was it, $5 million?
It's $1 million is the proposal for this initiative.
So you're let me think about it for a sec. I guess Commissioner Gilman, you're concerned even about the $1 million.
It's just not clear how it usefully answers the most pressing questions about kind of the measurement and legitimacy of the process that were raised at length by parties in this proceeding.
Would you have a view, Commissioner Plant?
Yeah, I mean, I think, sort of what I'm struggling with is kind of what Commissioner Gilman brought up. I think, the question to us is whether or not it's a prudent investment of ratepayer dollars based on, what the ultimate application would be. And, as Commissioner Gilman pointed out, this is in a different division, the oil and gas division, and their emissions reductions. It's possible, Mr. Chairman, that the process that you've identified may lead to something, but I don't know that it's necessarily a prudent allocation of dollars if we don't know what that end point is. And at this point, it seems like we don't.
I think there's a lot of endpoints we don't know. I mean, I'm fine.
All right. Then, based on your conversations, bear with me just 1 second. I'm just trying to add up what you have agreed to at this point. What we got here? And it looks like the budget cannot be right. Sorry. Yep.
$1 billion.
I see. All right. I'm sorry. I don't want to delay the proceeding any further. I will refer you back to Mr. Mendelson.
Mr. Mendelson?
Yes, well, Mr. Eden is next up.
Mr. Eden?
Thank you, Commissioners. I'm Michael Eden with your advisory staff. Got one issue for you, one vote. It's about the Renewable Connect Natural Gas Program, or the RCNG program. Public Service proposes this program as a voluntary opportunity for ratepayers to purchase bundled carbon offsets and renewable natural gas for a flat rate. The emissions reductions and product costs would be separate from the clean heat emissions targets and resource portfolio spending. The company explains that the cost of the RCNG product will vary greatly based on the ratio of renewable natural gas to carbon offsets and customer participation. However, the company intends for the program to be self-sufficient and that non-participant rates will not be used to support the RCNG program. Regarding the expected ratio, Public Service currently anticipates using about 95% carbon offsets and 5% renewable natural gas. In its statement of position, Public Service asserts that the voluntary programming, like RCNG, is imperative because it gets customers involved in the process. The company adds that RCNG can engage income qualified customers and renters in a manner that electrification may not. With some exceptions, the interveners generally oppose this RCNG program. Staff recommends that the commission reject the RCNG program because, one, the program relies on renewable natural gas projects that do not qualify as eligible resources under the Clean Heat statute, and two, the program relies on carbon offsets. In the alternative, if the commission approves the program, staff argues that it should be modified to, among other things, only offer renewable natural gas with no carbon offsets. UCA likewise opposes the RCNG program. In their joint statement of position, WRA, SWEEP, and Conservation Coalition also argue that the commission should reject the RCNG program because it provides a false sense of climate action, relies on likely overestimated reductions attributable to carbon offsets, and promotes an unfavorable use of renewable natural gas. For similar reasons, Denver, Boulder, Cosacia, and CREZ also oppose the RCNG program, arguing, among other things, that it is a distraction from more effective emissions reduction measures like BE. And I'll note that Boulder addresses this topic at length and argues in the alternative that if the commission approves such a program, several modifications need to be made to improve transparency and prevent the product from interfering with DSM and BE efforts. In contrast, and similar to its recommendation on recovered methane, Pipe Fitters seems to endorse this RCNG program. Unless you have any questions, I'll pause here for your deliberations, and I also have a recommendation if you would like.
Commissioner Plant.
Yeah, I think I heard the advisor recommendation is to reject it, and for a variety of reasons, and I would support that for the reasons that you articulated, Mr. Eden, in your narrative.
Commissioner Gilman.
Yeah, thanks, Mr. Eden. Look, I generally like the idea of customers who are willing and able to pay more to support, whatever share of greenhouse gas reduction progress they're able and willing to do. But to me, as presented, this product, as designed, is more likely to cause confusion and potentially frustrate the actual clean heat efforts than to aid them. Carbon offsets are a highly controversial way to achieve this, as we've seen play out throughout this proceeding. And despite the naming, which I think could be seen as misleading, the program's only proposed to utilize 5% recovered or renewable natural gas. So, I think the result here could be significant customer confusion about what this product actually is and is not. And the pricing of it based primarily on, almost entirely on, offsets that come from reductions outside of the distribution and use of natural gas. That pricing could, I think, severely undercut the actual price of mitigating emissions in the distribution and end use combustion of natural gas, which, after all, is our main priority here for the legislature. And I think it could serve to confuse customers and the market about the actual options and actual costs to reduce greenhouse gas associated with heating their homes and buildings. And so, I'm certainly worried it could be not only a distraction, but send very confusing signals to the market about the costs and available options to do this. And so at this point, as it's been presented now, this is not a product offering that I would support offering to customers.
I don't disagree with you, but may want to suggest an alternative path forward. And I would be interested in a voluntary program if it relied, as you say, Commissioner Gilman, less on carbon offsets and more on Colorado certified natural gas and recovered methane. There also needs to be transparency up front so that ratepayers are clear on what they would be electing to purchase. And as you say, I don't think we have the record here to create such a program. but was wondering if you would be open to encouraging the company to work with stakeholders and bring back an application with a more fleshed out voluntary program, something that would include small amounts of recovered methane, as the company says, maybe 5 or 10% at the customer's option to keep it economic. And then with a revised certified natural gas program that would address the concerns you've previously raised. So just wanted to explore whether you guys would be open to something like that, given that we don't have the record here. So Commissioner Plant.
Yeah, I mean, I think one of the big issues with this specific thing is the use of offsets. I think if you want to design a voluntary program, as we've discussed before, I think there's a variety of different issues that need to be addressed, but they're separate from the offset issue. So I think if we wanted to request that the parties work together on a potential voluntary filing that would be, outside of the offset market and look at the various different resources that you articulated, I would support that.
Commissioner Gilman, does that address the concerns you made before based on the evidence in this record? And I share your concerns with the offsets, but I think between a different set of mixes, we could come up with something that would be useful.
Yeah, I'm of two minds, so I fear I will fall short of encouraging it. I'm open-minded to the fact that there could be a voluntary project, a voluntary program that allows people who are able and willing to pay more to specifically support greenhouse gas reduction efforts. I think we have to give a lot of thought to the confusion that can cause in the marketplace in terms of the other kind of clean heat objectives. I also think, I don't know how long it's going to take for kind of the market to get a lot more clarity on CNG and appropriate baselines and appropriate vetting of technologies and all of the concerns that we've heard within this proceeding. So I'm not so confident like how near or long-term that the idea is that we'd get answers to the most pressing unanswered CNG questions. So I would have more reluctant language that I'm open to seeing this, but I am not necessarily encouraging it. In addition, I just want to point out something I pointed out before. I mean, the undertaking that we're discussing here on the part of the company in clean heat in general is massive. And so I am sympathetic to some of the arguments from parties that this could be a distraction. I think there's an avenue in which it could be useful to get kind of more voluntary, funding for some of these efforts, but I'm also cognizant that there's a lot going on here, a lot of new programs, big expansion of funding, and we need to see the core things this plan is intended to do done well, perhaps, before we distract ourselves with other things. So those are some of the reasons for my reluctance and why I'm not encouraging it, but I'm somewhat open-minded going forward that something could be more suitable than this proposal was.
Well, hopefully we can walk and chew at the same time. So I'm fine with the open to consider an application with a more fleshed out voluntary program that addresses the concerns you both raised. Does that work for you, Commissioner Plant?
Yes, it does.
All right, does that give you what you need, Mr. Eden?
It does. Thank you very much. I'll turn it over to Mr. Mendelson.
So, Mr. Mendelson, we've been going for 2 hours. Thinking maybe is the next issue the DSM, the total budget, or?
I was going to backtrack quickly to the gas consumption forecast. There's one quick item there that we did not address yet.
Yeah, why don't we address that, and then why don't we take a 5 or 10 minute break after we do that before we get into the budget?
Okay. So Commission Rule 4731A requires the company to conduct initial forecasts of sales, customer counts, system-wide capacity, throughput by fuel type and emissions, and include, among other things, the effect of current and enacted state and local building codes and changes in line extension policies. Notably, the CHP forecast is also shared with the GIP infrastructure planning process. And in response to the company's most recent GIP informational filing and proceeding 23M0234G, the Commission required extensive improvement to its forecasting processes to include all the relevant components under Rule 4731A. Those improvements are expected in the company's upcoming GIP application to be submitted in 2025. Nonetheless, the company explains here in its CHP application that customer counts have been growing 1.1% per year, mostly in the residential class, and weather-adjusted sales growth has been slightly lower at about 1% per year. Going forward, the company projects a slight decrease in gas throughput due to current DSM and BE programs. However, that throughput results in emissions that remain well above the 2015 baseline emissions, let alone meet the statutory 22% emission reduction target in 2030. Now, CEO argues the Commission should require the company to include in its forecasting the impacts of state building performance standards and local building benchmark and performance programs, as well as Colorado's state tax incentives for heat pump systems in the company's gas load forecast. CEO also contends the company's gas consumption forecast, which informs the resource selection model developed by consulting firm E3, failed to include mid-sized commercial buildings, large commercial buildings, and industrial customers. Advisors note that the CHP process by design or until modification only represents gas emissions among sales customers, that is, not those receiving transport service. It is generally understood, although the record lacks specifics, that large C&I customers procure primarily transport service from public service. However, there may be a small segment of such customers that do procure sales service from the company that could be better illuminated through company analysis. With that background, the decision point is whether the Commission needs to require modifications to the company's gas consumption forecast, as suggested by CEO.
I go to you first, Commissioner Goodman, on this one.
Been opinionated on forecasting. Yeah, I mean, look, obviously, good forecasting is the basis of this process. Everything builds off of that, which is why we spend a lot of time in the rulemaking trying to delineate the factors that should be included in forecasting, both for CHP as well as for the GIP process. So clearly, it's frustrating to have another process here where we do not have forecasting that's compliant with the rules. Many, if not all of the things that CEO wanted to see reflected in forecasting is already contained within the rule, and it just was not done. We have tried to lay out a process post-GIP to get there, as we see the forecasting effort as largely overlapping between clean heat plans and GIP. However, I do think CEO points out this one interesting area, which we also talked about a little bit last week, which is how kind of transport customers and those really, I think, throughput and capacity forecasts relate to retail customers in total, and probably point out an area where these forecasts may not entirely overlap, since statutorily the clean heat plan is only applicable for retail customers, whereas the GIP would have to be evaluating really all sales and capacity as we move forward. So as we look at that kind of forecasting effort, I think we need to keep in mind, which I think is already on a track we'll be setting, as we indicated coming out of the GIP in an M docket, to look better at how we can assist the company with moving forward with compliant forecasting. But this relationship of the transport and retail customers, specifically on the clean heat side, I think deserves some more focus, so we can better understand that relationship. I talked somewhat about perhaps some seams issues in the last deliberation meeting to figure out, okay, who is paying in to support these programs, who may be benefiting from the programs. And to the extent that we have some programs that are targeted at very large users, perhaps the company suggested demonstrations on hydrogen or flue gas capture. Those are very large customer programs that may primarily target transport customers. But the answer is we don't know. We don't know how many kind of these larger commercial or C&I customers are on retail service versus transport service. So I think that would be important for us to roll into our forecasting discussions so we can better really understand this issue going forward. So anyway, a long-winded way of saying, I think we have a process here, but there's an issue here that we need to fold into that process to get better data around throughput and capacity as it relates specifically to transport versus retail, and then also see those things rolled together for the GIP. So just, I think, an added thing for us to focus on in that effort that we've already discussed embarking on in the near future here.
Commissioner Plant.
Yeah, I mean, I appreciate those insights, Commissioner Gilman, help. And one thing I'm having a little trouble understanding, I understand that the transport, customers aren't specifically included in the programmatic aspects of the clean heat plan, but isn't when you're evaluating or forecasting throughput and capacity and all that sort of thing, they are a part of the system, right? I mean, wouldn't it make sense to have that included, even if they're not in terms of forecasting and impact on the infrastructure, since it's there, whether we're designing programs or not for those specific sectors.
Commissioner Gilman, Mr. Mendelson. Yeah, Commissioner.
I would just say quickly, I mean, that's where I see that, we had largely said in the rulemaking, well, let's not make them do two different forecasts, and the information should line up, right? Whether you're doing carbon reduction or infrastructure planning, we should have, one vision of what the future looks like for growth on the system. But this interesting nugget of how the clean heat plan specifically excludes transport customers means that inherently in the carbon math, they are excluded in the clean heat plan, both from the baseline as well as from, the targets or whatever their behavior is in the future. And so inherently, I think we still want to see the same kind of base forecast, but then understand, okay, what carve out of this probably is the transport customers. So then we understand what subset of this data are we looking at for a clean heat plan versus the totality of it for the GIP. And when you add up those parts, they should add to the whole thing we're seeing in the GIP. So I think we want to figure out how do we go about getting compliant forecasting, getting it to be consistent across the proceedings, but see this carve out in a really transparent way, so that we understand the transport customer piece of this.
Yeah, that makes sense to me. The other aspects of the CEO comments around, building policies and the state policies and incentives, that makes sense that those would be incorporated in projections as well. Do you agree with that?
Yeah, that's already in the rules. Yeah, any building codes and local or federal incentives are all factors they should be including in their forecasting. So I wholeheartedly agree, and I hope to see compliance with the rules.
I don't have anything to add to that. Does that give you what you need on this issue, Mr. Mendelson, to draft the order?
It does. Yeah, thank you.
All right. If we could take a 7-minute break till 11:20, that'd be greatly appreciated. See everybody at 11:20. All right, Mr. Mendelson, back to you.
Alrighty. Okay, now is a big item, total budgeted amount. As advisors understand it, the commission just approved the market transformation portfolio of approximately $65 to $75 million and recovered methane of $10 million over the 25 to 26 time period. Also, as advisors mentioned, we recommend that the commission use the flex-based plan as a starting point for your discussions. That plan includes $84 million for DSM and $366 million for PE over the 24 to 28 timeframe. Based on that initial starting point, the commission is currently looking at a budget of approximately $530 million in CHP spending. The company projects the 2030 emission reductions of the flex-based plan at 1.4 million metric tons. However, that value includes $100 million in recovered methane investment that is now reduced to $10 million. Also, not considered by the utility is the emission reduction value of the market transformation portfolio. Most of the MTP funding the commission just agreed to is for clean heat resources and should have a direct emission reduction benefit. Accordingly, based on those factors and advisors' rough estimates, we're approximately at an emission reduction level of 1.3 million metric tons. But that value should be confirmed by the utility as a compliance matter. At last week's CWM, Commissioner Chair Blank raised several concerns surrounding rate impacts and asked advisors to modify the company's long-term rate model, which is confidential attachment JWI4. Advisors completed that task and shared the modified model with each of you. However, we'd like to mention several caveats on the results, including the model incorporates a wide array of assumptions beyond the approval period for the CHP, including continued CHP investment, the trend line of transport sales relative to full service customer sales, and ongoing infrastructure investment. The model also has a series of limitations, including numerous pasted values representing output from one or more other models, the relationship between BE and DSM investment and decatherm sales reduction is unclear as the public service model produced inconsistent values year to year, and the public service model allocates 100% of costs of beneficial electrification to electricity customers and collects all CHP costs in the year they were incurred. That is no amortization. Advisors' adjustments to the model include two new scenarios, one representing the modified flex-based plan as it currently stands, and what I call the commission portfolio, which essentially allows you to adjust the flex-based plan using multipliers of annual spending. We also allow the model user to select from two cost values for BE and DSM, measured as the unit value dollar per decatherm spent. Approach 1 utilizes the output from the bench request, HE 145 attachment HRA 16, which required the company to remove the scalar mechanism and the constraint on AC replacements that the commission ruled against in last week's CWM. Approach 2 takes an average of the company output from the cost target and the emission target portfolios. The advisor model also allows the model user to assume a reduction in BE and DSM spending starting in 2031. It also allows the user to control new business and capacity expansion investment starting in 2026. Public services version assumes both categories decline quite rapidly. Given the limited time available, the advisor model did not add amortization capability to the CHP expenditures. Simply put, amortization will lower short-term but raise long-term rate impacts. That effect will diminish or grow depending on the length of the amortization period allowed. The commission has had a few days to assess the results by playing with the numerous input options. Overall, as reasonably expected, the analysis shows that rate impacts will be driven by the extent to which sales decline and how much spending on CHP expenditures and pipeline infrastructure continues beyond 2028. One additional consideration is that in response to the bench request, the company's flex plan without the scalar and AC replacement constraint, but with hydrogen and more recovered methane than approved by the commission here, resulted in slightly higher spending, but also projected to reduce emissions very close to the statutory reduction target. Importantly, cost recovery decisions will determine the rate impact felt by gas customers. I'll also note that per the flex plan concept to be discussed below, potentially another $119 million or another value determined appropriate may be available in 2027 to 2028 for allocation into any of the approved resources. Finally, advisors would like to remind the Commission that we are only approving the budgets through 2028 here in this CHP, and we will have numerous opportunities and requirements to correct course before and after 2030. At this juncture, advisors would like to ask the Commission to discuss the matter, but not take a final vote here unless there seems to be consensus on the budget.
Well, I just want to thank you, Mr. Mendelson, and the team for turning around that model in a really aggressive time frame. Just greatly appreciated, and I know the volume of work over the last months has been off the charts. So, just want to start out this discussion with a personal thank you to you and the team. Given all the uncertainties we've previously discussed, I'm struggling to approve the flex-based budget as proposed by the company, particularly the 2027-2028 ramp. In my view, the confidential rate impact analysis as modified by our advisors and myself shows rates doubling, potentially doubling over 10 years and maybe even quadrupling over 20. I know, as Commissioner Plant said, this is just a model. But to me, it's more like basic math. If we don't manage down ongoing capital spending in any meaningful way, greatly limit investments on cleaner molecules, and then invest over $500 million during the next 5 years in a manner that continues to ramp, according to the company model, into the hundreds of millions of dollars in ways that greatly reduce sales, then we're going to have substantial rate impacts. The legislature has asked us to balance conflicting goals involving emissions reductions and cost caps in a way that protects affordability for IQ customers. And I'm just having trouble getting comfortable with committing to these fairly aggressive budget ramps, sales reductions, and rate impacts as striking a fully reasonable balance. Most fundamentally, I don't think we have a clear vision on this record of the future of this natural gas LDC business. When coupled with our decisions to substantially restrict investments in cleaner molecules, I'm worried that the budget ramp may put us on an unsustainable sales and rate trajectory. And I don't know where this ends. We're going to have a $10 billion rate base with little or no sales. I just don't know where we're going. And for me, this concern is exacerbated by all the broader problems we saw in the GIP, in this case involving demand forecasting, managing capital spending by location, the cost effectiveness of the DSM and beneficial electrification investments, and as I said, the long-term rate impacts and the fundamental future of this business. For me, I think this all counsels caution and the option for a more modest investment, sales reduction, and rate impact path forward, particularly on the 2027-2028 ramp up. So I guess what I'm proposing for your consideration is in 2027, instead of a guaranteed $100 million spending, that we create a range of between 70 and 100 million, and for 2028 a range of 70 to 130 million. When coupled with our decision to increase the all-electric neighborhood new build program by 30 million, this makes for a total approved budget in this case of somewhere between $450 and $500 million. The exact point within this approved 2027 and 2028 range might be decided at our 2026 check-in point based on the company's progress in developing and success in developing the things we care about: on-bill financing, addressing the problems identified here and in the GIP regarding load forecasting, capital spending by location, meeting the requirements of Senate Bill 230291, and better understanding the cost effectiveness of DSM and beneficial investments. And that would have given us another 2 years to see the results of the 2024 to 2026 spending. So as such, I don't think the 2026 check-in needs to be a fully litigated, forward-looking clean heat plan, but rather more of a backward-looking filing in the current case. And from this perspective, the exact spending in the range we're approving today could be determined, as I said, based on 2 more years of experience and hopefully a clearer understanding of the future before we commit to the type of ramp ups in this budget. So I'll stop there. That's sort of where I'm landing for discussion purposes on the budgets. And like I say, my big concern is the ramp up, the 2027, the 2028. And, you know, when you look at the company's model, they're proposing to continue and expand that ramp up in investment until 2029, 2030, and continue it at very high levels for a long time. And given the uncertainty over rate impacts in the future of the business, I'm just not prepared to endorse that ramp up, that growth, and these rate impacts on this record. So I'll stop there and see where you're coming out, Commissioner Plant.
Thanks. So I'm not entirely sure I understand.
Yeah.
But I can ask some clarifying questions. So I think that with what the company's flex proposal was largely based on, you know, continued investment in supply side resources, which, you know, as you pointed out, are a continuing expanded investment over time. Whereas, you know, unless you subscribe to the scalar model, which I don't.
We've already agreed not to.
Yeah, we should probably, we would assume sort of the opposite as it relates to, you know, DSM and BE, that you don't have that continued investment in supply side resources as you go out. So, so I agree with you there in terms of looking at that model. Are you, I didn't quite understand in terms of, you know, we set the budget. I think the way that what most of the parties were doing was setting a DSM BE budget for the full 5 years. But there was a flex period where they were taking the money that was originally allocated to, you know, the renewable methane stuff and reallocating it among the DSM and BE, or, you know, in the company's, you know, proposal, including the supply side resources. Is there an amount there that you're proposing to reallocate, or are you saying we just stick with a 5-year?
I guess what I'm proposing is that we set a range in this case. And I guess I'm really looking at the advisor table, and I guess my numbers were focused more on the electrification, although they could be on the whole thing. And I'm just saying, we, you know, basically so the electrification, the number I have is in 2026 is 68 million. In 2027 is 99 million, and in 2028 it's 128.6 million. And I'm just saying we create a range that keeps it between 70 and what this is showing, 70 and 100 and 70 and 130 million. So basically it's approved, but it's subject to our review in 2026. And we could, on the table the advisors presented us on page 76 of the decision matrix, we could do it on the red line, the grand total. But basically I'm trying to get a handle on the 2027, 2028 ramp up, and make that increase subject to seeing what happens over the next 2 years, 2-3 years on all this stuff.
Yeah.
So That's
Okay, I think I understand. So there wasn't an additional budget that becomes available in 2027 that would be reallocated under yours. It's more of an allocation within the years.
yeah, and not like giving approval to the full increase at this time, because for rate impact and really all the problems we've been discussing for the last year or two in this business, forecasting capital spend, it's a way of not losing control of this until we get a little more understanding and get some comfort that some of these concerns are addressed.
Yeah. Well, I can tell you, I kind of did it a little bit differently because I was kind of assuming that we would have some flexibility between years. And so I didn't in the budget that I kind of prepared, I ended up at the same places in the total side, but I really just I said, 2024 is going to be half, and because we're halfway through the year, and then I just put, for example, in BE, I just had 80 million for each of the years, 25 to 28, 40 in 2024, and thinking that there would be.
Can you say that again? So 2024.
Yeah, so what I wrote down, and this is I don't know why it's doing that. And this is just like a simplified approach is, I had annual DSM budgets of about 20 with 10 in 2024 because it would be half. Annual BE budgets of 80 with 40 in 2024 because it was half. And, that basically comes out to 360 and 90, which, you could do 366 and 84. It kind of comes out to the same place. But then I had a period in 2027 where we took an additional budget amount, and based on the adoption rates, based on performance, whether we were closer to the PFB, whether we were closer, to the roadmap, whether we were closer to where the company thought our adoption levels would be, all that stuff would be taken into account, and we could reallocate those dollars in the 27 and 28 period. And so I had an additional budget of, 100 to 150 million that we would be looking at a reallocation, which would put the total higher than where you were talking about, because there would be that additional flex budget. But
so can you just so I'm looking at on the advisor memo, I'm looking at page 76, and I see it at the total budget amount, I see a graph with a red line at the bottom.
Right.
And can you just walk me through what numbers you change where?
Yeah, so what I won't talk about the vertical 1, vertical 2, or methane. Just looking at the gas DSM and the electrification lines. What I put in was didn't ramp up in the same way. I just put in, for example, under the electrification, 80 million in each year of 25, 26, 27, and 28, with 40 million in 24, because 24 is a half year, basically, is what I was basing that on. That total of that line comes out to 360, and their total comes out to 366. In the DSM, I put 10 for 2024 and then 20 for each of the years, 25, 26, 27, 28. That total comes out to 90. Their total comes out to 84. So it's kind of in the same ballpark, but I wasn't saying that we're going to achieve these different ramp ups in adoption, which are going to lead to these higher budgets year to year. I was thinking we could just put in a base budget, allow for some flexibility between years based on adoption rates, and then, in 27 say, okay, where are we? Are we closer to the PFB? adoption rates? Are we closer to the flex plan adoption rates? And have a budget that, an additional budget that in the event that we are at high adoption rates and we wanted to reallocate, we could reallocate. So the bottom line numbers without those additional funds in 2027 come out about the same, but I did have some additional flex dollars that would be available, which I think is the biggest difference.
Okay, and just to be clear, so on that red line in 2027, I'd probably say it's somewhere between 90 and 121.5 in 2027, and 90 and 150 in 2028. So
I'll tell you what, let's go to Commissioner Gilman, and I'll make some changes to my spreadsheet so I can give you the numbers you're looking for. I didn't have
Commissioner Gilman, you want to tell us where you're at?
I think Ms. Dundas wants you.
Uh-oh.
Sorry, I don't. No, it's okay.
One of us is in trouble. I suspect it's me.
No, I don't mean to disrupt the conversation. I just think for clarity for the public, you guys had been referring to a chart in materials provided by advisors, but what we're looking at is table JWI R4 in hearing exhibit 116 as modified by your decisions on Wednesday. So that charts their flex-based portfolio budget, and for your benefit, advisors had taken out the hydrogen lines and made the recovered methane consistent with your discussion, just so everyone knows what we're looking at, and no one wishes they had our matrix.
Thanks for the clarification, and I apologize for the confusion. Commissioner Gilman, anywhere you'd like to take us?
Thanks, Ms. Dundas. Yeah, so probably to me, the most important first question is kind of what budget are we looking at to be kind of modifying or tweaking or moving off of? And in the information we were provided after the bench request, there are additional scenarios run that include the removal of the incentive scalar and also include AC replacement as an available BE resource, which are not the assumptions that are used in the flex-based portfolio budget. So why it matters is because the model actually selects different amounts at different kind of cost effectivenesses, I don't know if you can say that, at a different cost effectiveness. And so for me, it is the most logical, given our decisions on those two items, in which case we disagreed with the fundamental premises used in the flex-based portfolio. I would tend to use the flex base that has been modified for the AC replacement, as well as the removal of the incentive scalar, as the most accurate representation of what the commission's already agreed to as being reasonable in the modeling to determine then, how it acts. So by comparison, the BE numbers are essentially the same, the DSM numbers. The DSM numbers are essentially the same as what you see in the flex base, but the BE numbers do go up more or less like 5%-ish for many of the years that you're looking at. To, I think, essentially reflect that there is more BE resource in that AC replacement, and that it comes at a pretty reasonable cost potentially. So that's what I would use personally as a starting point. It did have higher spending than the flex-based portfolio, but also achieves a significant amount more greenhouse gas reductions that actually get closer to the state target. So the way that I'm thinking about this is essentially looking at that as a basis, and just for your reference, DSM numbers basically stay the same as the flex base, but the electrification numbers that return in that model run in 2024 is 33.3 million. In 2025 is 54.8 million. 2026 is 75.2 million. 2027 is 105.4 million, and 2028 is 134.4 million. So to me, that's the most reasonable starting point, because otherwise I'm not so sure what the point of making those decisions before was in terms of what methods we're endorsing more. I think it most reasonable to then look at the modeling run that best reflects the version of reality we think is the most accurate. So in looking at that also, from the company's actual model run, there was about $116.6 million total of hydrogen and recovered methane investments that they included in their model run. We have only agreed to pursue $10 million worth of recovered methane. So there's essentially 106.6 million that were represented in that modeling run that would not be represented kind of in our base budget. We've talked about 30 to 40 million for that new construction program kind of enhancement. So the way I'm thinking of it is, I would essentially take, a base run that was shown by the company to be cost effective in terms of the flex portfolio, then the enhancements that the commission ordered in the bench request, and essentially take that more or less unused 106.6 million and allocate that essentially between the new construction program and then the remainder being a flex available to grow for 2027, 2028. But I would indicate that to me, that would only be to grow amongst approved clean heat resources represented in the plan we're approving, not going outside to new resources. I think that would make a pretty unwieldy process in 2026. I'm a little concerned in leaving just a wide range of budget open to that 2026 process, rather than saying here's an amount that you can augment on top if the demand and programs look to require it. I'm just not sure if we have like kind of a concise and approachable process in 2026. The more things left unanswered, the bigger that process looks and feels. So that's essentially how I was looking at it. So for reference, if you allocated 30 million to that new construction, to augment the existing budget in the new construction, I'd have us at about 76.6 million as a flex for 27, 28, and run that process, more or less similar to what we've seen. So that's my analysis.
So can you just walk us through whether, like, again, referring back to that advisor table, can you just walk me through what you see as the grand total that you're proposing we approve plus the flex?
And one thing I wanted to, before you do that, Mr. Mendelson, one thing I wanted to clarify in this table, there is no 5X for the new electric is built into the market transformation at the normal level. It doesn't have the 5X adder,
That's
right?
right.
Okay.
That's correct.
Make an adjustment.
Yeah, so I can take you through it either way. If I zero out what I'd include for the additional new construction BE project, would you like it that way, or would you like me to include a certain budget for that?
Whichever way you prefer.
Well, it seems more realistic since we all agreed to include a certain budget for that, but it won't line up as neatly with your numbers because now I'm adding in like $30 million.
Fair enough.
Okay. So I've added in $30 million spread in the same ratios over 2024 to 2027 as the company had. They had $500,000, $2 million, $2 million, $500,000. So I just allocated the 30 million in the same relative ratios per year. So you want yearly or you want total?
Yeah, if you could do yearly, that'd be great.
Okay. So 2024, that would be, I did not, should start by saying, I did not do the same sort of exercise Commissioner Plant did to limit the 2020 spending. I agree it's an issue. It's not ideal that like everyone knew this process would go into mid 2024 and we have whole year numbers at the same time. That was just not exactly my priority in looking at the bigger scheme of budgets to go through, I think it's somewhat likely that we will underspend in 2024, given that a good amount of the year has passed, but I've essentially kept the base numbers that were in the plan, although I acknowledge a good amount of the year has passed. Okay, so given that 2024, 58.1 million, 2025, 104.9 million, 2026, 122.2 million, 2027, 133.1 million, 2028, 158.1 million. That totals 576.4 million. And per my previous suggestion on essentially using the unallocated flex-based resources, hydrogen and recovered methane, that's in excess of what we approved, but allow it to be reallocated to essentially what we've identified as more cost-effective resources. After you take out the 30 that I have already included for the augmentation, the new construction, I would have 76.6 million. That's a possibility to have, in that flex spending.
So just so you know, I think we came up with almost exactly the same number total pre-flex. And then if you add in the 76 flex, and I don't know if I guess we just consider the 76 flex. We don't know how that divides year to year, but that would be decided in 26.
Yeah, to my understanding, it can only be 27 or 28. And like I said, we're not going to relitigate what resources are or are not permitted under the plan, but essentially allow it potentially to be an allocation among the approved resources.
So I guess my math may be a little different. So as I understood it, you were suggesting 450 million. Commissioner Plant with, what was the flex? What was your flex number?
I had originally about between 100 and 150 in flex.
So that gets you to 575, and Commissioner Gilman's at 650.
Let me see. So one of the big differences is I didn't ramp up the BE. I mean, the DSM numbers largely stay flat. I didn't ramp up the BE numbers as they ramp up here. So I was a little higher in the early 25, 26 and a little lower in 27, 28, but it essentially comes out about the same. And then I had included the 5X on the new electrification for 24, 25, and 26, but not for 27, 28, because I was thinking that would be included in flex. So
I have you more like 450 is your base and a flex of like 125. So I have you with a total of 575. I have Commissioner Gilman with a base of 576 and a flex of 76. So I have her at a base of 650.
From looking at my math, and again, I'm using a little bit different numbers. I'm at 518.8 before flex.
518.8 before flex, and then you have a 125 flex.
Yeah, I mean the flex.
All right, so you're close
to make it. Yeah.
And any thought on trying to have ranges and look at this in 2026? Commissioner Plant?
Any thought on, I'm sorry, what?
On like trying to create a range now and limit this spending in 2027 and 2028, or are you sounds like Commissioner Gilman is not a fan of putting ranges on this. Any thoughts on that?
Yeah, I mean, I honestly, I just think a lot of what we're doing now is trying to anticipate what the adoption rates are going to be, and we're just not going to have that information until, before the 27, 28 year. So I'm not sure from a range perspective, again, like I said, I didn't ramp up. So my range ends up much lower in 27, 28 because I have much higher numbers in 25, 26 because I used a flat number. So I mean, I'm comfortable with the numbers that Commissioner Gilman put out there. Like I said, at the end of the balancing, it comes out the same as my numbers, but they're year to year, they're different.
I have to say, I have to keep my numbers in the out years a lot better because I'm worried this is on a sort of an infinite ramp.
Well, again, I mean, I don't know that we're on an infinite ramp because a lot of what we're talking about doing is investing in a different resource than what the company was talking about investing in. And I think that was an issue as you're investing in, low carbon supply side resources. You have to continually invest in those, but the types of investments that we're talking about making have they have a cumulative impact on emissions reductions, but they also don't build on budgets out into the future.
Well, let me ask you both this. If, to hit the targets in 2030, it was clear we were going to double rates in 10 years. Would you vote to approve that? Commissioner Gilman? And
Yeah, I mean,
in 20 years.
yeah, gas rates is one metric that you can and should look at, but also I think there's a reason why the legislature referred to, benefits exceeding the cost. There are dramatic benefits in terms of reducing future investment in the gas system that can be realized through a reduction in throughput, as well as health and other aspects. Carbon reduction also a main goal and cost there. So to me, it's not really appropriate to look at it through only the lens of gas rates. I think it's concerning and it's part of what we need to be considering. But we've actually been asked by the legislature to take a wider view of that and to really ensure this sector does its fair share of carbon reductions to hit state goals economy-wide. And so, the other side of that coin is, are we okay with starting out vastly undershooting what this sector should be doing to carry its fair share of greenhouse gas emissions, for scientifically based targets across the entire economy? And that's an equally uncomfortable question, I think, to ask, if we dramatically cut budgets from what it shows would hit the greenhouse gas targets or get very close. And so I think it's really a balancing act. And I think, one issue is that a long-term rate model, that the vast majority of the impact there that you see an increase in rates is because of the drop in throughput. It's not because of the exact amount we're spending on the program in a year. And as you follow that through, it's a very difficult reality that the actions that drop throughput are the most cost-effective ways to reduce greenhouse gas emissions in the system. And so it ends up with us in a bind where, yeah, the measures that reduce carbon in the system do look like they increase long-term rate impacts. However, they still look to produce benefits greater than the cost of those endeavors, especially when we consider, across, different health and other issues. And so I think the priority going forward should really be to look at, some of the things we've been emphasizing, and are there other ways to look at, augmenting or transitioning a business model that, looks to be based on the presumption of continually increasing sales. And I think we're looking at a future where you probably don't continually increase sales anymore. And so are there measures like those we've already talked about, like network geo, ground source maybe in total, that can involve a gas utility and provide a way to have revenue and customers after, you see widespread electrification. And I think that's an open question. I'd certainly like to see more focus there than on a myopic view that this business model can't and won't change at all. If the business model can't and won't change at all, the future rates look difficult.
Yeah, I mean, the problem isn't this, I mean, the three of us are changing it by focusing on the new construction in a way that at least has a shot at managing down capital investment. But putting aside that, I mean, this is all about reducing emissions and very little to reduce capital investment. So, I mean, basically what we had in front of us, putting aside that one piece, is a plan that doesn't reduce capital expenditure, reduces sales, and as we've modified, it doesn't really create the option for a cleaner model. So it seems like it puts us on an inevitable path of, raising rates, unless the new construction can really help us manage down capital. So, I agree it's a balancing act. I just may land on a little more cautious place given some of the uncertainties we've seen, throughout this business, forecasting capital investment, locational issues, even the fundamental impacts of these spendings, just so uncertain. So I'd be a little more cautious, and balance it a little differently. But Commissioner Plant, you want to jump in?
No, I mean, I don't know. I think that, we have some sort of, as I think you pointed out, competing priorities. The policy priorities that we have, if you're going to have a zero carbon future, basically your carbon infrastructure is a problem, right? There's no way to pay for it. And it doesn't matter what part of your economy you're looking at. If that's the reality, you've invested, billions of dollars in a carbon infrastructure and you have a zero carbon future, you're going to have a problem there. And I think that's a problem that is an issue that is bigger than this proceeding. I think that we're going to have a number of dynamics associated with this, one of which may be, increased sales volume within the electric sector that it has downward pressure on rates potentially. The potential to, dynamically manage, would increase on the demand side. That could also have, some beneficial impacts on the customer base. The gas side is problematic. I mean, we're trying, if we succeed in our policies, number one, we should reduce the investments in the gas infrastructure. Still remains to be seen if that's going to happen, but we're trying to do that. And number two, we're going to reduce sales because we're reducing the amount of gas that we're selling. So, and I think, as Commissioner Gilman's point around, a modification of a business model from the gas company is a really important one. We're in a transition. All of that transition responsibility doesn't fall on us. We need to, achieve the policy objectives to the greatest extent we can. But in terms of, modifying a business model, that's gonna fall on the company. I mean, there needs to be a view towards the future from their perspective, and I'm sure there are a lot of people that are thinking about that at the company. But that's a big issue that's going to be, we're already feeling it throughout the system, even as we bring, large, high carbon resources, generation resources off. They're stranded assets. It's going to have an impact. And that same thing is going to happen in the gas infrastructure system as well. I mean, I don't know that there's a way to entirely avoid it.
Well, my concern is it doesn't just fall on the company, it falls on the customers who can least afford to pay it. And I hear you, Commissioner Gilman. I'd like to see us do our fair share based on the science. But I just think if the cost is too high, it doesn't really go anywhere. I think I interpret this legislation as trying to decarbonize our energy systems in an economically sensible and sustainable way. And for me, I'm just going to struggle to see rates double in 10 years. Well, go ahead, Commissioner Gilman.
No, I mean, the other thing that I'd point out is in looking at one exhibit, which very unfortunately is entirely confidential and we can't really talk about, which is functionally difficult. I think there are several assumptions in there in which we likely do not or would not endorse as well. So I think you have to take any outputs there with a grain of salt, especially including what happens after 2028. Our job here is to set us on a course, I think, for success for what this sector should do, pointing to what we understand to be the 2030, well, technically the 2025, but the discussion is centered around 2030 clean heat targets. We're not setting spending for post 2028. I tend to agree with Commissioner Plant. I think there's, certainly, I mean, if you buy the idea that rates will go up on this system, in addition to technology improvements and wider availability of contractors and equipment, it's in all likelihood going to be easier rather than harder to incent customers to electrify in the future. And so I wouldn't be endorsing any assumptions past what happens in 2028, because I think we really need to see we're at a pretty early point in this technology curve, especially in terms of adoption in the US, and to see where we get in the next few years will be very informative. So, any broad assumptions on like a increase in spending after this, I think is only just some assumption that we're not here to endorse or approve at this point in time.
I don't know. I mean, how much trouble have we had reversing capital budgets once it gets started, and once you get vendors and whole infrastructure supported by that, it's been incredibly difficult to
I mean, the
those
opposite though is public services, rooftop solar rebates started at $4 a watt. Right. So we have actually seen programs that eke down as the technology and availability curves met them, to ensure that we were not overspending based on the maturity and availability of the technology. So I think we do have examples where this has happened. And it was a similar deal. There weren't a lot of solar installers. The equipment was very expensive. And so will we see something similar? That's just simply not the decision we're making today, post 2028.
Yeah, but the difference was the steel for fuel had an fundamental economic proposition that drove the industry, that created a win-win-win thing between clean energy customers and the company. Here, there's no clear vision of that win-win-win outcome, because the reduced sales and continued capital investments just create this rate pressure. So it's just, there's not the same long-term win-win-win vision that we have on the electric side here. So
Yeah.
yet I don't know.
Yeah, the other thing that I think we do need to mention is, you asked about doubling of rates. I mean, a lot of customers saw their bills double, a couple of years ago during the winter when gas rates went up. And I think that, part of what we're doing here is reducing that risk of exposure to fuel volatility as we reduce a reliance on commodity prices. So I think there are, as we mentioned, some of the other financial advantages for customers, on the electric side. I think there's also, that financial advantage of risk reduction and exposure to, price fluctuations that I don't know how we value that. I feel like it should be able to be valued some way, but I'm not an economist, but I think there's a value there for the customers.
All right, well, that was the discussion I wanted to have, Mr. Mendelson. I mean, we're not going to vote today, but it sounds like it's going to be a 2-to-1 vote. We're going to approve a budget somewhere around 650 million with, I don't know, somewhere between 75 and 125 million in flex. I'm probably gonna draft a dissent expressing just some of my concerns given the uncertainties about the long-term future of this business, and I think that's where this is headed. So clarifying questions, or you want to keep moving?
We can keep moving. I think, we'll have a final decision. If you're going to dissent, then Commissioner Plant and Commissioner Gilman need to come together on those final numbers. But we'll take that at the end, I believe. If you're okay.
And you might bring this back next Wednesday to let them think about it and finalize. I mean, for me, Commissioner Plant, well, probably the ramp is more realistic. Although I like the flat better for me personally. So if you want to do that, I'll vote with you, and we'll
I always start
keep this flat. But I don't think that's the spirit of what you're intending. So I don't, Mr. Mendelson, what's next?
Okay, the next issue are the SEAMS issues. The company describes SEAMS issues as 2 major items: the availability and cost sharing of BE programs to customers who take gas or electric service from a provider other than public service, and similar questions of program eligibility and cost allocation as applied to transportation customers. Advisors present the issue of cost sharing or allocation among sales customers below onto the broader heading of cost recovery. Under the concept of program availability, the company proposes to limit BE program available through the CHP application to combination customers that take both gas and electric service from public service. The company explains it is proposing this limitation only for incentives provided during this nascent stage of clean heat programs, and is not opposed to expanding electrification programs to its gas-only customers in the future. Public Service suggests not all potential electric providers for our gas-only customers are likely to be parties to this proceeding, and we expect this will not be an issue unique to Public Service. The company suggests the Commission open an M docket within 60 days of a final order in this proceeding to explore these SEAMS issues and other questions that arise that require Commission and stakeholder input prior to the filing of the company's next CHP. Boulder suggests the Commission require the Public Service offer DSM and BE programming to gas-only customers. It is inequitable, they say, to provide Public Service's combination gas and electric customer support and incentive to take advantage of DSM and BE programming while leaving their gas-only customers with nothing. Boulder notes that Public Service provides gas-only service to at least 33 communities. And they also say that Boulder supports proceeding with an M docket to address cost allocation, but does not agree that an M docket is necessary to provide DSM and BE programming to its gas-only customers as part of its CHP compliance. Staff suggests the Commission direct the company to make BE offerings available to all customers who are eligible for the company's other DSM offerings. The company's proposal to limit BE spending to areas where it provides both gas and electric service is an unnecessary course change from what this Commission approved in the company's SI proceeding. May make that statutory emissions target more difficult to achieve and more costly, and simply frustrates the purpose of the CHP. CEO supports the company's proposal to limit BE programming to areas where the company provides both gas and electric service, and the company's proposal to open an M docket to determine how best to handle SEAMS issues. The company responds if beneficial electrification spending is paid for using an electric side rider, as the company proposes, gas-only customers that electrify would receive a subsidy from the company's electric customers, but would not themselves contribute to paying for their own electrification, nor would they contribute to the electric system as a whole via their new electric heating demands, which would benefit another utility's electric system. I'd also like to note that Commissioner Plant suggested at last week's deliberation that the Commission asked the AQCC to develop a beneficial electrification protocol, and the APCD apply this protocol to the evaluation of gas compliance with the emissions reductions required under that statute. This would establish a market for credits that all electric and gas utilities can use to buy and sell credits that will be used for gas companies to establish compliance with the statutory reduction targets. Commissioner Plant went on to say such a market would effectively remove the seams issue. As economic regulators, this is outside of our area of regulation. However, for the air regulators, it is something they have done for the CHP process already with methane protocols in an area in which they have extensive expertise. Commissioner Plant also suggested having a SIM with AQCC and APCD to describe what we're after, but not an M docket that he argues would not give us any actionable information that we don't already have. So the first decision point is, does the Commission agree to limit BE programming to combination customers, or should BE programming be available to gas-only customers as well?
Commissioner Plant?
So I may have a different perspective on this. I was trying to think about this from the customer perspective, and it's again, we're a little bit at odds because obviously the compliance regime falls on the gas companies, and we're also in a situation where some of our all of our gas-only customers are served by utilities that are outside of our jurisdiction. Our electric-only customers are served by gas companies that really don't have any beneficial electrification that they're offering as a program for the customer. And so you've got this real range of incentives across the customer base, and I was trying to think of ways in which we could try and even that out as much as possible. And so what I came up with was the idea of having it apply to all customers, have it split 50-50 in electric and gas customers, 75%, 50 or 75% for gas only customers, assuming that their electric company is going to have some sort of an incentive around beneficial electrification, and then 100% for electric only customers, with the thought that if the AQCC could develop a BE protocol, and then that can be an instrument for gas companies to comply with their statutory requirement, that would be something that could be purchased from those electric-only customers for the purposes of compliance. And so there would be effectively a split in the costs that would come afterwards. So that's kind of my thinking on it. And, a lot of this was really triggered in terms of this thought of the emissions. It was triggered by the conversation I had with Ms. Fickling from WRA when I proposed a kind of a straw proposal, something like what I just described to you. And, her response was that there would need to be some way to allocate emission reductions and compensate, customers for their contributions to emissions reductions, if we were to pursue something like that. And the other aspect of this that I am trying to figure out, a way for us to address are the propane customers. because they don't have a compliance requirement. But yet when we start thinking about, you know, impact on both economic impact as well as you know, emissions impact, that can be some of the you know, best customers to target, but oftentimes are left out of this formulation just because we're limited by the utilities that we're talking about in terms of gas and electric. So I was trying to find some way that we could include them and create a value that's associated with their emissions reductions as well. So that's kind of what I've come up with, but I look forward to hearing you guys.
Before I turn to Commissioner Gilman, just a question, and this may be outdated, but isn't the AQCC incredibly jammed up? Aren't they way behind on even statutory obligations, or is that no longer true?
I honestly don't know.
All right. Commissioner Gilman?
Sure. Well, I'll start with the base question. I think Mr. Mendelson asked, which was if the clean heat programming should be available to gas-only customers or only combined customers. I would tend to agree with staff that limiting BE to combination customers is a course change from what we approved in the SI proceeding without much difference in data or plans here. And I do think it would frustrate the purpose of the clean heat plan, you know, looking at the potential of 20-25% more customers, especially as we heard throughout the proceeding, what was described as an unprecedented level of new electrification. I think having a wider net in part helps make it more feasible to get to those targets, but also makes it much more fair for those gas customers. It strikes me as quite difficult to complain and explain the fairness of why, if you're a gas customer, and you'll receive different benefits depending who your electric supplier is. So to the layman, this could be very difficult if we end up splitting hairs. And I think part of what we all need to focus on is making these programs much easier to communicate and deliver to the end consumers as well, so that this is not a gauntlet and they're able to participate easily. So for really all the reasons staff and many of the other parties laid out, I would support offering the programs to both combined and gas-only customers. With regard to Commissioner Plant's proposal, I think it's interesting. I think it's interesting to kind of broaden the market and say, how can you kind of garner a benefit or some compensation from something that is happening in these areas? I'm not so sure we or CDPHE have the bandwidth maybe to take it on right now. I would be fine with like a suggestion that there are very interesting avenues that could be considered here, but probably fall short of something way more formal because I have no idea, you know, if they have the bandwidth or how that process would really start. But I think the problem you identify is an interesting one, and like bringing an innovative idea and solution, and I appreciate that. It makes some sense to me that something like that could exist, but to get from here to there could be a pretty arduous process.
I agree with Commissioner Gilman's comments on the last point. Geez, I'm struggling with you know, I take Commissioner Gilman's point about the and staff's really point about the difficulties in communicating to customers and trying to distinguish between gas only and combined customers and explaining that to gas only customers, but I just worry about the rate impacts of what we're doing here. I think the prior decision was based on much smaller dollars and much smaller impacts, but I don't know that I'm going to try and dissent on this one, but would like to think about it.
So if I could ask a sort of a clarifying question. So I think Commissioner Gilman, what you were suggesting is having it go to gas and combined, gas only and combined customers. Did you have a percentage?
So I think these are separate questions. The percentage allocation would be on the cost side. I think the first question Mr. Mendelson teed up was, should the programming, essentially the benefit side of the programming, be available rather than the cost side? I don't think he's maybe gone through that question yet. So with regard to the benefit side, I do think it should be available to both combination and gas only customers. But here's Ms. Dundas.
I assume you do too, Commissioner Planner.
Yeah, I do. The only difference I had was I was also extending it to electric only customers with the assumption that we would have a way of allocating their emissions to various different, either, the Excel gas company could buy them, or, if it's, for example, a Piesco customer that's being served by Atmos Gas. Atmos isn't going to obviously offer, is not proposing to offer any kind of CHP incentives on beneficial electrification, for example. But in order to maintain those services being offered to the electric customers, that we would offer it to them as well. And that's where you get into the issue of, would there be a way of, allocating those emissions reductions to the compliant agencies or companies. And so that, I think that's the only difference between what I think Commissioner Gilman was proposing and what I was proposing is the electric only population.
Ms. Dundas.
Just a timing note. We have to stop at 12:30 to get the room done for the hearing that starts at 1. So it might be good to stop the discussion here and discuss when we will pick this back up.
I think next Wednesday, right?
Well, if I could, we have a lot of decision matrix left to work through. And honestly, it kind of makes me nervous that we would leave so much for next week's CWM. Would the commission be interested in a CDM tomorrow to continue? It looks like there's availability at 3 o'clock on your schedules.
I can do that.
I can do either that or on Friday as well.
Friday looks tougher.
Oh, hold on, I'm in the wrong week. What time did you say tomorrow, Mr. Mendelson?
3 o'clock. We could go for a couple hours and probably get most of the remaining decision points covered.
Friday morning may be better for me.
Friday morning. It looks like Commissioner Plan has something at 9.
I'm available Friday morning.
Oh, I'm sorry. I think Chair Blank said tomorrow morning.
Oh no, so I meant Friday morning.
Oh, Friday morning. Okay. Well, it looks like 10 to 11 is open, but is it possible we could go past that?
I'm open, so.
Okay. Chair Blank,
Commissioner Gilman.
The choice is between tomorrow afternoon and Friday morning.
Yeah.
Yeah, and Friday morning might be able to be available as early as 9:30. I'd have to get, there's a chance I could push it a little earlier, but I need to work some things out that I can't do live. So I could either do, I can do 9:30 to 11:30 Friday, or I can do 3 o'clock tomorrow. Either works for me fine.
Why don't we do 9:30 to 11:30 on Friday? Would that work for you, Commissioner Plant?
Okay, so we have consensus on that time frame.
Yes, 9:30 to 11:30 Friday, May 10th.
So we'll stop here for today.
Yep.
Okay. All right, thank you very much. Okay, we'll see you Friday. Thank you for your time.
And then I guess we got a rulemaking hearing at 1, 30 minutes, no rest for the weary. All right, thanks all. See you in a bit.